Oh. I seek your Lordship's indulgence, Your Lordship. I have several matters listed before the Honorable Division Bench. In fact, the trivial matters have been remanded by the Supreme Court, and there's a direction to dispose them of within 3 months. And the matters are listed today, Your Lordship. So, Your Lordship, if this item 3 may kindly come up tomorrow or on Friday.
Item 3.
Yes, ma'am. If this can come up tomorrow or on Friday, Your Lordship. Wednesday, DB day.
What about Thursday?
Thursday, Your Lordship, our colleague is getting married, Your Lordship. Mr. Joseph Bentley.
Thursday also, I mean Friday also, a slight problem is there from my side. Can have it next week maybe.
Next week,
Next week, Tuesday.
I'm online.
Item 3, right? As paid for by Mr. A.R. Malhotra, Learned Counsel for the petitioner. State is there
State is
and not objected to by the other side. List the matter again on 29th of October 2024.
I'm online. The state may kindly continue till then.
Sorry?
Interim
Lord,
may kindly
if
continue.
I may, if this matter may be taken up tomorrow, because there is an interim stay, and pleadings are already completed.
Notice is incomplete. Notice on respondent number 4 is still incomplete.
Tomorrow may not be possible. Thursday, Friday. It happened on Monday. Monday.
Yes, my lord.
In fact, the private respondent is there.
Yes.
So we have to wait for that also.
Yes.
Let's see. What did I say? 29, is it? Make it 28. Or make it 29. Let it be on 29. We'll go by 29. Yes.
I'm
Don't change it. Interim order passed earlier to continue till then. Yes. Any other mention?
I seek a lordship's indulgence in making a mention, my lord. Item 8, this is listed for hearing. If it may be passed over, my lord, for tomorrow. Two of our office staff relatives have passed away. Would like to attend the funeral, my lord.
Not tomorrow. Some other day. Any other day.
Thursday. Thursday also, my lord. Yeah, Thursday there's a wedding. Friday also, my
Wedding
lord.
is in the afternoon, isn't it?
Wedding.
12. 12 for me.
It's at 2 p.m. or 3 p.m. like that. We'll try it on Thursday. Make it on Thursday.
All right, my lord.
If not possible, we'll see. Okay. As paid for by Ms. Linda L. Fumble on an additional AG. Paying for the state respondents and not objected to by the other side. List again on Thursday, 24th.
Obliged.
Your Lordship, may I seek court indulgence in mentioning item number 7 on behalf of Miss Mary. She is having some family problem and she is stuck in Jampai.
Mr. Malhotra.
It's okay. 10.
Similar prayer to item number 10, my lord. 7 and 10.
Item 7, you write, on the prayer made on behalf of Ms. Mary L. Kiangte, learned government advocate, being for state respondents and not objected to by the other side. Matter stands adjourned for 2 weeks.
Obliged.
In item 10 also, similar order. Instead of government advocate, you'll write additional PP.
Your Worship, I have a similar prayer in item 9 also, Your Worship. This matter may come up after a week.
As paid for by item 9 by Mr. A.R. Malhotra. Have you informed the other side?
Yes, Your Worship.
As paid for by Mr. A.R. Malhotra, learned counsel for the appellants and not objected to by the other side. Matter stands adjourned for a week.
I'm okay.
May I seek your lordship's indulgence in making a mention of an unlisted item, my lord?
Unlisted.
Yes, my lord. This is of extreme urgency, my lord. It pertains to contract matter for which a tender was open, and the bidding will be open tomorrow.
Have you participated?
Yeah, my lord, we are aggrieved that it is a matter pertaining. Yes, we have been prohibited from entering into the bidding, my lord.
Why?
Because our firstly, we had a contract with the respondents for which we are illegally terminated, my lord, which was not as per the contract agreement signed between the parties, my lord.
You were terminated, so you have been debarred from participating in
Yes,
future
my lord.
contracts.
My
What
lord.
is wrong in that?
There
You
was
have, you have to challenge that debarring order. You're
yes,
challenging
we are challenging as well.
No, that is one thing to challenge that debarring. The other thing is regarding the fresh tender. So how do you kill two birds with one stone?
My lord, we are praying for a stay only because there's an alternative remedy that was available for which the respondents failed to act on it.
Have you filed the writ petition?
This is, yes, we have filed, my lord.
When?
Friday,
On Friday?
yes.
Okay. And what is the other thing that you are supposed to do before mentioning?
Oh, we have also given notice to the respondents, my lord, state respondents.
Have you informed them that you'll be mentioning it and it's likely to be taken up?
Just a few minutes ago, my
It
lord.
shouldn't happen that matter reaches and there's nobody to appear for the other side. Then we cannot take up the matter like that. Okay, we'll see.
Much obliged.
Please inform the other side.
For orders, item number 5.
May I seek your lordship indulgence? My lord, my senior is on legs. If the matter could be passed over for the time being.
There's hardly any matter left for time being. Why don't you do it yourself? What is the matter about?
My lord, I believe it's for condonation of delay of 500 and more than 500 days.
More than 500 days.
525, my lord.
Okay. You have objection?
No, my lord.
You have no objection?
I have no objection because, my lord, in the previous court date, I have prayed time for listing today, my lord.
You have the file with you?
No, my lord.
Okay, we'll pass it over there.
Much obliged.
Oblige.
Item number 6.
Yes.
Say that again.
1 and 2.
Yes, my lord. Even in this case, my senior is on next.
And also, my lord, my senior, she's on her way. The briefs are with her.
So what is to be done then? 1 and 2. Then it's 5 also, isn't it?
Yes, my lord.
We call the Jamatar, I'll rise. Let the parties be ready. I'm here. Once everyone is ready, I'll come back.
For this item number 5.
At the outset, Your Lordship, I would like to tender my apologies. I was on leg in the before the division bench.
It's okay.
May it please Your Lordship. My Lord, this is an application for condonation of delay for a period of 525 days in filing the connected appeal. The appeal is directed against the judgment and order, the order of the senior civil judge whereby heirship certificate was issued to the present respondent. Now, my Lord, the reasons for delay White order dated 1/6/2022. White order dated 1/6/2022. Heirship certificate number bearing 1156 of 2022.
How many days delay you said?
525.
The order is passed by whom?
Court of the senior civil judge, Aizol.
Dated
Dated 1/6/2022.
in
Heirship certificate number 1156 of 2022.
Mr. Counsel, you said you have no objection.
I have an objection, my lord, regarding the Passover, my lord.
Oh, your no objection was regarding Passover.
Yes, my lord.
I thought your no objection was regarding the dish.
That would have been very helpful. So, in any event, Your Lordship,
Okay.
the property in question belongs to my grandmother, whereas the respondent is the son. However, I, as the granddaughter, was living with my grandmother in the suit land, whereas the respondent, being the son, had maintained a separate house for more than 20 years at Chanmari, whereas the suit land in question is in Lengpui. In any event, Your Lordship, so no notice was issued when the heirship certificate was issued in favor of the respondent. No newspaper publication, nothing. So I came to learn about the issuance of the heirship certificate when the respondent told me to vacate the premises. So I approached the senior court of the senior civil judge and filed review number 40 of 2022 on 14/10/2022.
Review.
Yes, Your Lordship. I had preferred a review against the heirship certificate.
How much? Number?
40
Of
2022.
okay. Then?
However, that was in October 2022. I filed a review. However, Your Lordship, upon advice received from my counsel, that review 40 of 2022 was withdrawn on 15/11/2022. On 15/11/2022. This order is at page 15 of my application.
Why did you withdraw?
Because I had taken under advisement that it would be better to prefer an appeal.
So this is the appeal.
No, my lord. What happened was that an appeal was filed before the court of the additional district and sessions judge,
When? What is the appeal number?
RFA 21 of 2022.
RFA?
21 of 2022.
Okay.
And subsequently, Your Lordship, this RFA was dismissed via order dated 10/7/2023. This is at page 17, annexure 4, for lacking pecuniary jurisdiction.
10/7/2023.
Yes, Your Lordship.
Then?
And the dismissal of this RFA was never informed to me by my counsel. So on 24/11/2023, I was given a legal notice by the respondent through counsel to vacate the premises on the strength of the heirship certificate and in light of the dismissal of the RFA. So legal notice was served to me on 24th of November 2023. So immediately, and as I mentioned earlier, Your Lordship, I'm a resident of Lengpui, and I could not immediately meet my counsel, but I met him and requested him to hand over the brief so that I can get legal advice from some other advocate. And that brief was finally handed over to me only on 12th of December 23.
Yes.
And thereafter, Your Lordship, the appellant had engaged my services on 19th of January 23, and the period in between was court holidays on account of winter vacation.
So when did you file this?
I filed it on the 7th of February 24 this year.
Appeal filed
Yes.
along with the CMA.
Yes. So, our humble submission and prayer before this honorable court that this delay of 5 to 5 days was due to bona fide mistake, and by virtue of section 14 of the Limitation Act, the said delay may be condoned.
The review was filed on which date?
Review was on 14th October 22. Four months after the airship certificate was issued, because we were not aware of it at that time.
Was it accompanied by condonation of delay application review?
Most probably, because I don't have that information, Your Lordship. I apologize.
Review, there's a limitation of 1 month, I think.
Right.
30 days. So, the airship certificate was allowed on 1st of June 2022.
Without notice.
Then review was filed on 14/10/2022.
Correct.
However, it was withdrawn after about a month,
Right.
in November. Then appeal was filed on
I don't have that particular date with me, but it was in the same year, in 2022 itself.
when review was withdrawn in November.
Yes. So, most probably in
So
December.
probably by December it had to be filed. Nomenclature says 2022.
Correct, Your Lordship. So,
Then it was dismissed on 10/7/23.
right. For lack of pecuniary jurisdiction.
Then this information was not given to you.
Yes.
How did you come to know? Only from receipt of the
Legal
eviction-
notice.
Legal notice or eviction notice?
Legal notice.
Legal notice from whom?
From the respondent through advocate.
Okay. That was on 24th of November.
November. So I requested for the brief to be handed over to me, which was handed over to me on the 12th of December. And thereafter, the week after that onwards, it was winter vacation in the Aizawl bench.
No, winter vacation, you don't stop working. Courts are closed, no doubt. But do you also stop working?
I also stopped working
Was it?
because of the winter vacation. Normally, we
You
don't.
take advantage of the break,
Right.
do your homework that time.
But in any event, Your Lordship, the brief was handed over to me only on the 19th of January, after reopening of the courts.
Brief was handed over to you in January,
January of this year.
but you said 12th of December. Just
No,
now.
no. The brief was handed over to the appellant by the previous counsel.
Okay, to the appellant.
Yes.
Then you received the brief on 9th of
January.
January.
Thereafter, I filed it on the 7th of February.
So about almost 1 month you took.
No, my lord.
7th of January to 9th of January to 7th of February.
19th of January.
Sorry?
19th of January.
Okay, 19th of January.
So about 2 weeks.
So the entire delay is counted from 1/6/2022 till date of filing, isn't it?
No, my lord. 90 days, deducting 90 days period of
Obviously.
appeal. After 90
Starting
days,
from 1/6/2022 to date of filing is 7/2/2024 minus 90 days.
right. So I am basically relying on the provision of section 14 of the Limitation Act, which reads as follows, with your lordship's permission.
Wrong forum.
Wrong forum. Bona fide in court without jurisdiction.
Just a minute. Section 14.
Your lordship has it.
Yes.
Section 14, exclusion of time of proceeding bona fide in court without jurisdiction. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence under this civil proceeding, whether in a court of first instance or of appeal or revision, against the defendant shall be excluded where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which, from defect of jurisdiction or other cause of a like nature, is unable to entertain it. As I mentioned, Your Lordship, the RFA was dismissed for lack of jurisdiction.
So at best, you can perhaps utilize this provision from the date of filing of your RFA till it was dismissed.
Right. But
Which,
at the same time, Your Lordship, this unfortunately, the dismissal of the RFA was not immediately communicated to me.
it's more than 4 months, isn't it?
Yes. it's
Dismissal
about-
was 10/7/23. Your legal notice receipt was on 24/11.
Right.
So after more than 4 months, you received the notice, then only you came to know about the dismissal.
Correct. I was not informed.
So how do you explain your conduct in the sense that you have given that brief to your counsel, then you forgot the matter?
It's not about forgetting the matter as such, Your Lordship.
For 4 months, you were not asking what has happened to my case. What
I was
about my
under
appeal?
because I was under the impression that the appeal was still pending. Because time and again I would inquire, but then every time I was kept on in being informed that it's still pending. And plus, it was my understanding and my humble opinion that it was the duty of the council to inform me about the outcome of the appeal, whether
It
it's
is equally your duty also to find out what has happened to your case.
yes.
See,
That is
you
also
have
there,
spent a lot of money hiring your lawyer. You spend a lot of money. Every month, at least once or twice, you should ask, what about my case? What happened? When is the next date?
Right.
I mean, that's what's done. It's not that you engage a lawyer today and you, after 1 year, you come back and say, okay, what happened to my case? You cannot just, be obvious of the developments. It's right that your lawyer should have informed you, no doubt. Equally, you should have also asked, what about my case? So that's what I'm pointing out.
That is definitely there. So in a ways, there was a duty was cast on both parties to a certain extent. That I believe that is correct, Your Lordship. However, one should not lose sight of the fact that in this particular case, Your Lordship, a grave injustice would be caused to the applicant herein, inasmuch as, Your Lordship, the heirship certificate was issued without following any procedure and against the provisions of the principles of natural justice. Not a single notice was issued. On the same day, it was given. And I have throughout have been living with my grandmother. And whereas the respondent herein has maintained a separate household in Aizawl, I've been living with my grandmother in Lengpui in the same house in the suit property where she passed away.
That will be an argument on merit.
Right.
As of now, the duty of the applicant is to explain to the satisfaction of the court that you had been not able to come to the court due to all these reasons which are bona fide. Now, where is this page 15?
Page 15 of my
Review, I think,
right.
dismissal or the withdrawal of the review.
Page 15, Annexure 5.
Withdrawal with liberty to file afresh. 11.
Page 17 is the order it passed in the RFA.
What is the explanation of your counsel for not informing you for 4 months?
He simply said he forgot.
That's not very professional, is it?
No, my lord.
You cannot just forget.
In fact, my personal practice is that we update our clients every time there is a court date, on either by a phone call or a WhatsApp message.
Whether your case is dismissed or whether it's allowed, duty is cast upon the lawyer to inform the client that this is the
Absolutely, Your Lordship.
thing. Please come over. This is what has happened. We need to discuss.
I mean, although I have not mentioned this particular issue on record, but the previous counsel was partly taking part in the political activities. It was the election year also. I think that was the excuse.
There was more than one counsel, is it?
One, my lord, only one counsel.
Only one counsel.
Oh, it says others, but
It says others. There's more than one.
right. But the lead counsel's name is definitely there. So his reason was that because of that particular year being an election period, he was busy with his other activities.
Okay, anything else?
No, that's it, Your Lordship. But
Any authority?
I have one judgment.
Yes, what is that?
I've given a copy. This is a civil appeal arising out of a SLP number 17665 of 2018. Urni Devi and another versus Babu Ram and another. The relevant paragraph is at para 31. Sorry, para 30.
This is not reported.
No, I don't believe so, Your Lordship. It says reportable, but I couldn't find it. Maybe it's still a bit relatively new, Your Lordship.
Yes.
Para 30. The principles pertaining to applicability of Section 14 were extensively discussed and summarized by this court in Consolidated Engineering Enterprises, wherein while holding the exclusion of time period under Section 14 of the Limitation Act to a petition under Section 34 of the Arbitration Act, it was observed. So I'll just skip this next one since it's a basically reproduction of those section. Actually, I'll read it since I'm already on it. Section 14 of the Limitation Act deals with exclusion of time of proceeding bona fide in a court without jurisdiction. On analysis of the said section, it becomes evident that the following conditions must be satisfied before Section 14 can be pressed into service. Both the prior and subsequent proceedings are civil proceedings prosecuted by the same party. The prior proceeding had been prosecuted with due diligence and in good faith. The failure of the prior proceeding was due to defect of jurisdiction or other cause of the like nature. The earlier proceeding and the latter proceeding must relate to the same matter in issue, and both proceedings are in a court. This court in Consolidated Engineering Enterprises further expounded that the provision of this section must be interpreted and applied in a manner that furthers the cause of justice rather than abort the proceedings at hand, and the time taken diligently pursuing a remedy in a wrong court should be excluded.
So what benefit you get out of this?
Since my
Date of filing of the appeal and dismissal of the appeal.
right,
But remains that leaves a balance of how many days?
around roughly 4 months,
Total is 5 days.
right.
Anything else?
In fact, Your Lordship, in regarding that 4 months period, as I had mentioned, I was not informed. Although I don't have it today, the Apex Court has clearly held that the client should not be made to suffer due to the follow of the advocate. So in the instant case also, I was never informed about the dismissal of my RFA.
That's why I was saying that it's equally your duty also. You cannot just blame upon your lawyer that you have not done this.
No,
you have
once,
not told,
once I have
you did not
engaged
inform me.
once I have engaged my counsel, I fully trust
There
him
is
to-
also a decision of the Apex Court wherein the client is also supposed to be vigilant. You cannot just give the brief and say sleep over it,
right, Your
thinking
Lordship.
that he'll take care of everything.
And unfortunately, as we all know that sometimes in the lower court, things take slightly longer than usual in cases especially. So, in fact, in my humble opinion, 4 months being not a very long period, it is not a case where I slept over my case for a period of a year or so. It's only a period of 4 months, and I was not informed about this. And I should not be made to suffer due to these 4 months, Your Lordship. As soon as I came to know about the decision of the First Appellate Court, I immediately took steps on my part. I immediately consulted another lawyer who asked me to obtain the brief from the previous counsel. Accordingly, the brief was handed to me only in December of 2023. And thereafter, it was an ensuing holiday. As such, I could not meet my counsel, and I met him as soon as court reopened and handed over my brief to the present counsel in January of 19th. And immediately the appeal was drafted and filed. So this brief period, so to say, a period of 4 months, although Your Lordship is definitely right that I should have also inquired, but at the same time, this period should not be made to taken as a point to make the present appellant suffer, my lord. Because I was not informed. I was kept in the dark. Had it been a case of maybe 1 year, 2 years, definitely Your Lordship is absolutely correct. Because there have been instances in the lower court where matters are listed after a period of 2 months also. 2 months, 3 months. In fact, I have a few cases. We're in the month of October where my cases are being listed for the month of February in 2025. As such, Your Lordship, it is a humble prayer that this period of 525 may be condoned and that the appeal may be heard on its own merit. I conclude my submission with that, Your Lordship.
Yes.
May it please Your Lordship. My Lord, my first submission under paragraph number 5 of my written objection. My Lord, the appellant herein had made a wrong statement regarding the filing of the RFA and the review. So she had stated that the review was filed on 14/10/2022. But the correct is that after she came to know that the heirship was granted to me without notice, she had acknowledged that in the month of October 2022. And then after that, the RFA was filed first on 17/8, my lord. 17/8/2022. That is at page number 8 of my written objection. my lord.
17/8/22.
Yes, my lord. RFS was filed first.
Case number
8.
8 of
My written objection, my lord.
2022.
Yes.
Written objection where?
Uh,
Paragraph? Page number?
Page number 8, my lord.
Sorry?
Page number 8.
8.
Yes, written objection I have submitted, my lord. Annex 1.
Yes, Annex 1.
Yes, the correct date is given at the top.
What is this?
This is the a case record maintained by in the district court, my lord. I have obtained a certified true copy, my lord.
Case record means what? This is
This
cover?
is the case filed before the district court, my lord.
This is the registrar.
Yes, my lord. RFA was filed on 17/8. And on the next page, my lord, page number 9.
Just a minute. Just.
Okay.
You said RFA 8. But the nomenclature here is RFA 21.
Yes.
So why did you say 8?
The page number 8, my lord. I mean page number 8.
Okay. On 17/8/2022, RFA How much was filed? Number?
RFA number 21 of 2022.
RFA 21. Okay. Then?
And then on the next page, my lord, that is the review register. Review was filed on 30/9, 2022.
Review 39. Okay.
Okay. My lord, herein the applicant herein had made a wrong statement. So after the RFA was filed, she had engaged another counsel to file a review. So the counsel came to learn that the RFA was already filed, and then he had withdrawn the review application, my lord. So herein incorrect statement made in the application is it can be the sole ground to dismiss the condonation application, my lord. So I have the authority, my lord. Puntlik Jalam Patil versus Executive Engineer Jalgaon Medium Project and another. Citation is 2008 0 Supreme.
Just a minute. What is your good name?
S. Van Lalfreta, my lord.
Paragraph?
Under paragraph 11, my lord.
11.
Yes, my lord. Under paragraph 11, I will not read the entire paragraph, my lord.
Why
The
not?
operative portion is at page number 5, the next, the last paragraph, under paragraph 11.
No, why don't you read the paragraph 11?
My lord, all these things are not relevant, my lord.
Because this court does not believe in reading just 2-3 lines like that.
Okay, my lord, I will read.
Please read. 11.
Para 11, whether the respondent made incorrect statement in the application seeking condonation of delay. There is no dispute whatsoever that the respondent, being the beneficiary of the acquisition, has been duly impleaded as a party, respondent in the reference cases as is required in law. It not only appeared in the matter to a properly instructed counsel, but also filed its written statement opposing the claim for enhancement of compensation, but did not choose to lead any evidence whatsoever. In the application filed in the High Court, the plea taken by the respondent is as under. The applicant submits that, although the applicant, being a acquiring body, was arrayed as opponent in the said reference, the opponent number 4 herein, SLAO or his subordinate, contested the said reference by filing written statement. Therefore, this application was unaware about the stand taken by SLAO as well as the impugned judgment and award. This averment in the application on the face of it is totally incorrect. The Law and Judiciary Department, as early as on 13/4/2000, that is to say, within the period of 15 days from the date of the award of the reference court, communicated its decision to acquiesce in the decision of reference court and communicated the same to all the concerned, including the beneficiary of the acquisition. It is not the case that the executive engineer did not receive the said communication. Having received the said communication, the respondent did not act in the matter and initiated any steps for filing the appeals if it was really aggrieved by the decision of the reference court. There is no doubt whatsoever in our mind that the respondent made totally incorrect statement in the application filed in the High Court. We express our reservation as to the manner in which a public authority conducted itself in its anxiety to somehow get the relief from the court. In our considered opinion, incorrect statement made in the application seeking condonation of delay itself is sufficient to reject the application without any further inquiry as to whether the averments made in the application reveal sufficient cause to condone the delay. That a party taking a false stand to get rid of the bar of limitation should not be encouraged to get any premium on the falsehood on his part by condoning.
So this is what you wanted to read,
Yes, my lord.
this last line.
Yes, my lord.
Okay. Now, one thing you see, you say that the appeal was filed first,
Yes, my lord.
review was filed later on.
Yes,
But the appeal was dismissed on 10/7/23.
my lord.
How is that possible?
Because, my lord, that will be my next ground.
No, just,
where-
oh, okay, this is 23, sorry.
Yes,
The next year,
23.
2023.
23, my lord.
Okay.
Almost 1 year, my lord.
So your first objection is false statement.
My lord.
What else?
My next submission is that, my lord. So after the RFA was filed, a written objection was filed at the initial stage. And in that written objection, the pecuniary jurisdiction was raised. And then we have stated that this honorable court has no pecuniary jurisdiction to entertain this appeal. The proper forum would be the High Court. So in spite of that, the appellant herein proceeded the matter, and after that, the appeal was dismissed.
Where is your statement to that effect?
In under paragraph number 5, my lord.
5.
Yes.
Please read your paragraph 5.
In reply to paragraph number 2, subpara 1, 2, 3, and 4 of the application, I beg to state that after airship certificate 1156 of 2000 was issued in my favor, the appellant herein had filed RFA number 1 of 2022 before the learned additional district and session judge on 17/8/2022. And after filing of the said RFA, the applicant herein engaged another counsel and filed review application number 40 of 2022 before the learned senior civil judge on 30/9/2022. And the same was withdrawn on 15/11/2022. Therefore, the applicant herein appellant had made incorrect statement regarding the filing of RFA, and review application are paragraphs under reply, and on this ground alone, the application liable to be dismissed outright. I also humbly beg to state that the appellant herein had filed RFA number 21 of 2022 before the learned additional district and session judge. Written objection was filed at the initial stage, wherein pecuniary jurisdiction was raised in terms of the Mizoram Civil Codes Amendment Act 2021. Despite pecuniary jurisdiction was raised in the written objection at initial stage, the appellant did not take any step to withdraw the same and continued the proceedings, and ultimately the RFA was dismissed on 10/7/2023 due to lack of jurisdiction. In view of the facts, there was a bona fide negligence on the part of the appellant in pursuing the matter, which is writ large on the face of the record.
What do you mean by initial stage?
My lord,
What is the date? Date, month, year? RFA was filed on 17/8/2022.
along with the RFA, condonation application was also filed, my lord. And in that condonation application, I have filed a written objection, and I have mentioned that jurisdiction also, my lord.
Exactly.
Yes.
I'm asking you about your objection. What is the date of your filing of your objection? You just said initial stage.
Yes.
It's quite vague. You should have a date.
My lord, my written objection in the condonation application was registered on 9th November 2022 before the notary public. And then I think I cannot recall the exact date of filing before the court. I think maybe on the same date, because I have not, they didn't provide the certified true copy of this written objection.
November 2022.
Yes, my lord.
November 2022.
My lord. 9th November. It was registered before the notary public, my lord.
But it does not necessarily mean that you'll submit immediately. You can submit it after a few days, after a few weeks also, isn't it?
Yes, my lord.
Only problem is that, only thing is that you got it notarized in November 2022.
My lord, the same has also been reflected in the dismissal order dated 10/7/2022.
Where?
In
Page?
page 18 of the application. That is the order.
Which part?
Page 8, third paragraph, my lord. Fourth paragraph. The second last paragraph. Page.
Which paragraph? Third paragraph, second last.
Which?
You are giving me 3 or 4 paragraphs.
Four, my lord.
It's not numbered, I know,
Yes.
but there are paragraphs here. Which
Yes.
paragraph?
Fourth paragraph, my
From
lord.
the top. From the top.
No, from the top is continued before the next page, my lord.
You are at page 18.
Yes.
Are you at page 18?
Yes, my lord. Of
There
the
are 1, 2, 3, 4, 5, 6,
5, my lord.
7 paragraphs. Which one do you mean?
Five
Which one?
paragraph, my lord.
1, 2, 3, 4. It begins with what sentence?
It is further argued.
Yes, please read.
It is further argued by the respondent OP that if a will executed by the deceased were to exist, it is necessary that a competent court to be approached for probate of will, and that having not being done, that argument has no standing. Mr. So-and-so also argued that the heirship certificate application number so-and-so was issued with respect to parties, the value of which amounts to more than rupees 10 lakhs as per the current market value. As such, this court lacks the jurisdiction to hear this appeal.
Okay. Your submission regarding jurisdiction is here.
Yes.
Actually, we were more on the date of your filing your WO. When did you file? This is what we wanted to know.
Yes, my lord, that the written objection in RFA, I keep the certified to copy that was received by the Lord Appellate Court on 17/4/2022. But before that, I have filed the condonation, written objection on condonation application. So I have also raised the same question, my lord.
No, question is when did you file your written objection? Because your submission was that
Yes.
after she filed the review, the first appeal. Listen,
Yes, my lord.
please listen. After she filed the first appeal, you immediately, along with the condonation of delay application, you immediately filed one objection. And in the objection, you have clearly pointed out that the court does not have the pecuniary jurisdiction.
My lord.
Despite that, the appellant or the other opposite party did not take any step, and they were just waiting for the court to dispose it off. This is what you meant, isn't it?
Yes, my lord.
So that is why I was asking you the dates. It will be crucial because the date disposal of the first appeal is there. That is, it was dismissed on July 10th, 2023. It was filed on August 2022, 17 August precisely. So almost 1 year it was pending. So if you want to convince the court that I have immediately given one written objection, but for almost 1 year they did not take steps, so they cannot have the benefit of Section 14 of the Limitation Act. That is why you were required to point out the date on which the objection was notarized was somewhere in November 2022. And you say that it's also available in the judgment or in the order of the lower first appellate court. Date is not here. It just records about your objection, that's all. Anyway,
My lord, in the order, see also the the date of receipt of the written objection was not mentioned in the order sheet. I have here a certified to copy, my lord.
No, you should have found out by the meantime, because you have drafted this objection, you should have found out the date and incorporated, as simple as that. And you should be meticulous with your filing. You are maintaining your own file there, your brief. You should put a note somewhere there. Filed objection today, the date. Case disposed of today, date. That will be helpful to you. Otherwise, every time you'll have to go running to the district court, to the record room and find out what has happened. You can always put it on your own file. Your number one point was that statement is wrong.
My lord.
Appeal was filed first.
My lord.
While appeal was pending, they filed review.
My lord.
Later on, the lawyer did not want to carry on. After finding out there was an appeal, it was withdrawn. So for that, you've given one judgment.
My lord.
Wrong statement will lead to non-condonation of delay. Second statement, second submission made by you is that you have raised the objection of pecuniary jurisdiction
My lord.
immediately. By filing objection to the condonation of delay application. But appellant did not do anything. Simply waited for the dismissal of the appeal. These are the 2 points.
My lord.
Any more points?
Yes, my lord. My lord, regarding section 14 of the Limitation Act.
Yes.
So nowhere in the application of condonation of delay, the appellant herein did not claim an exemption under section 14, my lord.
Okay.
So, in my humble opinion, my lord, this cannot be claimed at the stage of hearing oral submission, my lord, because she did not mention in her application. And then my next submission is that, my lord, if under paragraph number 6 of my written objection,
Yes.
I have stated that the appellant herein had gained knowledge of the dismissal order dated 10/7/2022 in RFA number so and so, only when the eviction notice was sent on 24/11/2023, that is 113 days from the date of dismissal order.
Is it so?
Yes, my lord.
I thought it would be more than that. Date of dismissal is 10/7/23.
My lord.
An eviction notice was, legal
24.
notice was given on 24/11.
My lord. Due to the reason that her counsel did not inform that dismissal order.
The reason's okay.
Yes.
I'm asking you about the calculation. Is it correct?
I think, my lord.
113.
113, my lord. As per my
Because
calculation.
July, 10th of July
Yes.
to November 24th. August, September, October, November.
Excuse me.
It's more than 4 months. There are 30 days in a month. 3 into 4, 12. It should be not less than 120 days. Your calculation is only 113 days.
So sometimes in the month, 31 days are there.
I'm not taking 31 days. I'm taking 30 days only.
Okay.
Even then, it will be more than 120.
Okay, my lord. As per my calculation is maybe.
Only in March,
Yes.
on the month of February or March, you'll get less than 30. The remaining part of the year, months of the year will be more than 30, 30 or more than 30. Anyway,
Okay, in this regard, my humble
you don't
submission
want to be precise, it's okay. It's up to you.
My humble submission is that, my lord. So the applicant has to be vigilant in her case, and she should contact and maybe take part in the proceedings. So this is, she cannot entirely put a blame on her counsel. She should be diligent in her case.
Okay.
What is the matter? So I think, in my humble opinion, my lord, this explanation is a concocted, and there is no due diligence on the part of the applicant, my lord. My lord, regarding the wrong forum, I have one authority to rely on.
Yes, what is that?
Ramji Pandey and others versus Swaran Kali. Citation is 2010 0 Supreme SC 1023. The operative part is at paragraph 12.
Yes.
May I read, my lord?
Read.
The appellants move the said application under Section 5, read with Section 14 of the Limitation Act. At the time of hearing of the said appeal, it was pointed out in the objection filed by the respondent against the application under Section 5, read with Section 14 of the Act at a very early stage that such an appeal is not maintainable before the district court, as it lacked pecuniary jurisdiction to entertain the said appeal, and therefore it would have been appropriate for the appellants to withdraw the appeal and file appropriate proceedings before the High Court. The same having not been done, and having obtained an order in their favor, which ex facie was illegal and without jurisdiction, the appellants are not entitled to take the benefit of Section 5, read with Section 14 of the Limitation Act. So, my lord,
So?
what I think...
Isn't it
Yes,
slightly
yes.
different?
Yes. My lord, maybe, so the appellant, yes.
Listen. In this case, Section 14
Yes,
was not given. The
Yes,
benefit of Section 14 was not given. Why? Because the party knew that there was no pecuniary jurisdiction on the part of that court entertaining the application. Despite they proceeded,
my lord,
and they also succeeded.
my lord.
It was not dismissed. It was allowed. In this case, it was dismissed. In this case which you're referring to, it was allowed. So they got the benefit of the order of the court, despite knowing that it was not, it did not have the pecuniary jurisdiction. That is why this court, what is this court? This is Supreme Court.
Yes, my lord.
Supreme Court said that you should not get the benefit of Section 40 because your conduct does not show that you should be getting this benefit. Perhaps this is what the apex court has meant. Anyway, the principle more or less is the same, only the outcome is different.
Okay, my lord.
You have given your objection. Despite that, they did not take any steps.
My lord.
In this case also, they had given objection.
My lord.
The court also did not listen to the objection and allowed the application.
My lord.
Ultimately landed up before the Supreme Court. Supreme Court now says that you should not be getting this benefit.
My lord, my last submission, my next submission
Yes.
is under paragraph 7 of my written objection.
Yes. Read.
I stated that if the counsel in RFA number 1 of 2022 handed over the brief to the applicant on 12th December 2023, and the same was handed over again to the present counsel by the applicant appellant on 18/1/2024, there is no explanation for reasons of delay of that period from 12/12/2023 to 17/1/2024 for handing over the brief to the present counsel, my lord. So, my lord, my humble submission is that if the applicant was diligently pursuing his case, so the brief was handed over to her on 12/12/2023, but the same was handed over again to the present council only on 18 of January 2024, my lord. So if he pursued the matter diligently, she should have handed over the brief immediately to the present council, my lord. So there is no delay of explanation within that period, my lord.
Festive season, that's why probably. Court was closed.
My lord,
Christmas, New Year was there.
2023 court was closed
Council had
only on
gone somewhere else.
17/12, only on 17/12.
Okay. Seventeen, 12. You mean
I think 17 or 18/12, my lord.
court was closed from that
Yes,
day?
my lord.
Okay. And reopening?
Reopening, I'm not sure, maybe 13th of January.
See, all these things you could have incorporated in your objection if you had taken some more pain to find out the dates and incorporate in your objection to be very precise. That would have been to your advantage,
My lord,
isn't it?
my lord.
Any more submission?
My lord, my humble prayer is that, so on the entire reading of the application, the appellant herein did not pursue her matter with due diligence. There is some bona fide diligence on the mistake. So, my lord, she did not pursue her matter diligently, my lord. So I pray this honorable court to dismiss this application.
Okay. That's all.
That's it, my lord.
Mr. Fakoma, you are not properly informed about the appeal being filed first.
Yes, Your Lordship. In fact, I can only rely on what the information that was provided to me. But so, as per from the written objection of the respondent, it appears that the appeal was already pending when review was filed. Apologies. Most probably that was the reason why review was withdrawn later on. But the fact of the matter is that, Your Lordship, it is clear and apparent that the applicant on her part was acting diligently and pursuing the matter in the best manner that she thought was correct. Now, as far as the raising of the pecuniary jurisdiction before the appellate court was concerned, Your Lordship, the respondent could have easily prayed for a preliminary hearing on maintainability. That was also never done by them. So on our part, just because an objection has been raised doesn't mean that we are supposed to take his word for it, since the matter was already pending before the concerned appellate court, rightly or wrongly. So we were just waiting for that adjudication, Your Lordship. Apart from that, Your Lordship, what I've stated in my humble, in my application, this honorable court may treat the same as sufficient grounds for condoning the delay, Your Lordship. That I conclude my submission and
Okay, please write down. Heard Mr. Lal Fakoma, learned counsel for the applicant, and also Mr. S. Banalchieta, learned counsel for the respondent. Stop. By filing this application, the applicant seeks condonation of 525 days delay in filing the connected regular first appeal against the order dated 1/6/2022, passed by the Court of Senior Civil Judge, Roman 4, Aizawl, in heirship certificate application number 1156 of 2022. Stop. Next para, Mr. Lal Fakoma, Learned Counsel, submits that heirship certificate application number 1156 of 2022 was filed on 1/6/2022, seeking heirship certificate on the property in question, and the same was disposed of on the same day without issuance of any notice. To stop, the applicant, upon coming to learn about the same, filed review application number 40 of 2022, which however was withdrawn on 15/11/2022. Stop, the applicant thereafter filed RFA number 21 of 2022 before the lower appellate court, but the same was dismissed on 10/7/2023 for want of pecuniary jurisdiction by the lower first appellate court. Stop, the applicant was unaware about the dismissal of the regular first appeal and only came to know about the same when a legal notice was served upon her on 24/11/2023 by the counsel for the respondent. Stop, the applicant thereafter approached her counsel and she was handed over the case brief on 12/12/2023. Stop, the applicant then engaged the present counsel by handing over the brief on, what was the date?
19-1.
19/1/2023.
24. Your Lordship.
Sorry, 19/1/2024, who then prepared the appeal to be filed and was able to file the same on 7/2/2024. Full stop. Next para. The learned counsel submits that since the applicant was unaware about the dismissal of the RFA number 21 of 2022, she was all along under the belief that her interest was being taken care of by the appointed counsel. But when a legal notice was served to her on 24/11/2023 for vacating the property in question. It was only then that she realized that the appeal had been dismissed. Stop. The learned counsel submits that due to the fault of the engaged counsel, the applicant should not be made to suffer. Stop. Secondly, as the applicant was pursuing the case before the lower appellate court, which ultimately was turned out to be not the correct forum to file the appeal. And therefore, the applicant who should be given the benefit of Section 14 of the Limitation Act 1963 by excluding the time which was spent in pursuing the case. In a court without jurisdiction. Stop. The learned counsel submits that since there is also merit in the claim of the applicant, we cancel them. Please rewrite again. The learned counsel also submits that the applicant also has good grounds of appeal on merit, and therefore, even on this ground, the delay should be condoned. Stop. The learned counsel, in support of his submission, has relied upon the case of Purni Devi and another versus Babu Ram and another, rendered by the Apex Court by judgment dated 2/4/2024. In Civil Appeal number dash of 2024, arising out of SLP bracket C number 17665 of 2018. You had only one citation, is it? Okay. Stop. He thus submits that the application seeking the condonation of delay in filing the conducted appeal may be allowed. We'll continue in the second half at 2.
You can do that.
Next paragraph. Mr. S. Vanalfieta, learned counsel for the respondent, on the other hand, submits that the applicant has made wrong statement about the filing of the review petition before the regular first appeal before the court below. Stop. He submits that RFA number 21 of 2022 was filed before the review petition on 30/9/2022.
17.
Sorry,
my lord.
sorry. What did I say last sentence? He submits that on 17/8/2022. Whereas the review petition was filed on 13/9/2022. Full stop. He submits that because of the incorrect statement, the instant application for condemnation of delay should be dismissed. Stop. In support of his submission, he relies upon the case of Pandik Jalam Patil bracket capital D by LRS versus Executive Engineer Jalgaon Medium Project and another. Two 2008-17 SEC 448. Stop. He further submits that nowhere in the application for condonation of delay has the applicant relied upon Section 14 of the Limitation Act, and that it is for the first time that submission in this regard has been made by the learned counsel for the applicant. Stop. He submits that the respondent, in fact, had submitted written objection to the application for condonation of delay in filing RFA number 21 of 2022 before the lower appellate court, clearly stating that the appeal was not maintainable for want of pecuniary jurisdiction by the lower courts, pecuniary jurisdiction by the lower appellate court. Stop. However, despite such objection, the applicant, as opposite party, failed to take any steps despite knowing that the pecuniary jurisdiction of the lower appellate court was limited. Full stop. The appeal was finally dismissed on this ground, and therefore the benefit of Section 14 cannot be available to the applicant. Stop. In support of his submission, he relies upon the case of Ramji Pandey and others versus Swaran Kali, 2010-14 SCC 492. What was your third submission?
My lord.
What was your third ground of objection?
The other ground is brief was handed over.
Okay. The learned counsel, next paragraph, further submits that according to the applicant, brief was handed over to the applicant by her appointed counsel on 12/12/2023. But however, he in turn handed over the said brief to the present counsel only on, what was the date?
I was handed over the brief on 19/1/24.
On 19/1/2024. Stop. Therefore, there is no explanation about the delay of about 37 days between the two dates. Full stop. In absence of any explanation in this regard, the delay should not be condoned. Full stop. The learned counsel lastly submits that the applicant has not been vigilant in getting the updates about the status of the appeal filed before the lower appellate court. Stop. He submits that according to the applicant, the regular first appeal was filed No, you cancel that line. He submits that, rewrite again, okay? He submits that the regular first appeal was filed before the lower appellate court on 17/8/2022 and the appeal was dismissed on 10/7/2023. Gustav, apart from the counsel for the applicant having failed to inform the applicant about the dismissal of the appeal, the applicant herself ought to have inquired about the status of the appeal, and which she failed to do so. for months together. Stop. As such, the applicant having failed to be vigilant right from the time of filing the first appeal before the lower appellate court, the delay in filing the appeal before this court should not be condoned, and the application should be dismissed. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. So from the you cut that. The respondent has annexed copy of the abstract from the register of cases before the lower appellate court, which goes to show that the date of filing of the RFA 21 of 2022 was 17/8/2022, and that the date of filing of the review application number 40 of 2022 was 30/9/2022. Full stop. It therefore appears that the appeal was filed before the review application. The review application was, however, withdrawn by order dated 15/11/2022. Full stop. As for the regular first appeal, the same was dismissed by order 10/7/2023. After the withdrawal of the review petition. Stop. reliance has been placed on the case of Pandlik Janam Patil, bracket D by LRS Supra, by the counsel for the respondent. To show that incorrect statements made in the application seeking condonation of delay itself is sufficient to reject the application without any further inquiry. Of the apex court, in that case, the apex court in the given facts of that case was of the view that party taking a false stand to get rid of bar of limitation should not be encouraged to get any premium on the falsehood or on his part by condoning the delay. To stop the respondent beneficiary of acquisition had not initiated any steps whatsoever before expiry of limitation, and that no circumstances were placed before the court that steps were taken to file appeals. And that it was not possible to file the appeals within time. To stop, it was under such circumstance that the appeal filed before the apex court was allowed. Stop, in the present case, the regular first appeal was admittedly filed before the review petition. on 17/8/2022. And the review application filed on 30/9/2022. Stop. The review application came to be withdrawn on 15/11/2022. By seeking liberty to file afresh. Stop. Admittedly, no further review petition had been filed thereafter. Stop. The contention of the applicant that the review petition was initially filed and thereafter, after its withdrawal, the regular appeal had been filed. In the considered view of this court, cannot be held to be detrimental to the case of the applicant. And that the case under reference is not similar on facts to the present case of the applicant. Stop. No doubt, the applicant ought to have been vigilant in inquiring about the status of the appeal from her appointed counsel. But then, the applicant, in the considered view of this court, should not be held accountable for the fault of our counsel in not informing her about the dismissal of the appeal. Stop. On merits, the rival parties claim that they have a better right to claim on the property in question by virtue of their relation to the deceased person. Stop. It so appears that the heirship certificate had been issued without contest from any other interested persons, including the present applicant. Stop. Therefore, upon due consideration, this court is inclined to take a liberal view to condone the delay in filing the connected appeal. Stop. It may also be stated herein that the benefit of Section 14 of the Limitation Act as provided by the said provision can be availed of by any party who had proceeded to pursue the case bona fide in a court without jurisdiction. Stop. Therefore, the applicant, although may not have taken a specific plea the same is always open to be raised at the time of hearing. Having regard to the benefit given by the said provision. Stop. Under the circumstance, the application for continuation of delay in the considered view of this court should be allowed, and accordingly the delay of 525 days stands condoned. IS stands disposed of.
Deeply obliged.
Then in the main appeal, in view of the order passed today in IAC number 12 of 2024, the appeal be listed for admission after a week.
After.
You have a copy of the appeal?
No, my lord.
I'll serve it in just now.
A copy of the memo of appeal be served to the learned counsel for the respondent, Mr. Vanosieta. Yes, Vanosieta. By the appellant. Yes.
Deeply obliged.
Obliged.
Supplementary list for motion, item number 11.
Yes. What is this case?
May it please your lordship. My case pertains to the illegal and arbitrary termination of my contract by letter dated 23/9/2024, my lord. And now that the respondents have floated a tender for continuation of the remaining work, and I also have been debarred from filing my bid, my lord. I would also like to state that the contract clause provide for an alternate dispute redressal, which is at clause 25 and part 2, clause 3. Although I have stated to the respondents that the need for the appointment of the dispute review expert may be done, till date the respondents have not appointed anyone. So I have not been giving any.
Where is the award of contract?
Yes, my lord. Page 86, my lord.
What work is this? This is an agreement
Yes, my
or
lord.
award of, what is this? 86.
Yes. 89, my lord, sorry. Construction of double lane BUSG bridge over River Langkai on Mizoram Tripura border at Kanhon, Mizoram.
Double lane BUSG bridge.
It's a built-up steel gird.
It's a bridge.
Yes, my lord. With your lordship's permission, if the leading counsel may take up the case.
Yes, sure. Yes.
Please, Your Lordship. Now, Your Lordship, if Your Lordship permit, I'll give a brief overview of the matter, Your Lordship, just to give an idea of the dispute, Your Lordship, which has occurred between the parties, Your Lordship. Now, Your Lordship, in 2018, Your Lordship, on 6th of March 2018, a contract was executed, Your Lordship, between me and the PWD of Mizoram, Your Lordship. The contract, Your Lordship, was for 22 crores, Your Lordship, and it was for construction of BUSG bridge, Your Lordship, stand for Built Up Steel Girder Bridge on Langaya on Mizoram Tripura border at Kanham, Mizoram, Your Lordship. Now, Your Lordship, the construction period for constructing this bridge was 24 months, Your Lordship. And because it was only for 24 months, there was no escalation provided under the contract. So it was a fixed rate contract executed between the parties. Please.
Where's the award of contract?
Award of contract start at page 89, Your Lordship. And the relevant page, Your Lordship, is at 95, Your Lordship. At page 95 is the letter of acceptance, Your Lordship. Your Lordship, may kindly have page 95, Your Lordship?
Yes.
Please, Your Lordship. Now, pursuant to your furnishing the requisite performance security as stipulated in the ITB clause 34 and signing of the contract for the work of construction of double lane BUSG bridge over R Langaya on Mizoram Tripura border at Kanham, Mizoram for the contract price of rupees 22 crores 3,25,600. You are hereby instructed to proceed with the execution of the said works in accordance with the contract documents. Your Lordship. Now, Your Lordship, please note that the time allowed for carrying out the work is 24 months and will be reckoned after 10 days from the date of the issue of this letter. So, Your Lordship, the work was for 24 months, Your Lordship. And thereafter, Your Lordship, now the work was illegally, arbitrarily terminated by the respondents, Your Lordship, on 23rd of September 2024, Your Lordship.
Where is that?
Please, Your Lordship. It is letter of termination, Your Lordship, is at page 458, Your Lordship. Your Lordship, you have
23rd,
it?
yes, 23rd September.
Please, Your Lordship. Now, Your Lordship, before I read this, go to the termination letter, Your Lordship, if may I allow to give a brief overview, Your Lordship. Now, Your Lordship, what has happened in during this period, Your Lordship, from 2018 to 2024, Your Lordship, it is an admitted position. I am not relying on my letters, Your Lordship. I will rely on the respondent's authority letters, Your Lordship. No land was provided to me, Your Lordship. No fund was allocated to me, Your Lordship, for construction of bridge. Now, subsequently, in year 2022, January of 2022, the nature of work was completely changed, Your Lordship. Earlier, I was supposed to construct BUSG bridge. Now, in 2022, suddenly they decided, no, you should not build BUSG bridge, but you will.
No, see, before that,
Please, Your Lordship.
you say that this work is supposed to be complete by 2 years,
Yes, Your Lordship.
24 months.
Yes, Your Lordship.
And the issuance of notice to proceed with work was issued on 27 March 2018.
Please, Your Lordship.
So by
2021, this
By-
work took.
2021.
Yes,
nine-
Your Lordship.
No, by
2020.
by 2020, you
The
were
wo-
supposed to complete.
Yes, Your Lordship. But they have given, I have applied for the extension of time, Your Lordship, and they have given extension of time, the engineer, till November 2024, Your Lordship.
How many extensions?
Majorly, one extension, Your Lordship, by the engineer, Your
How
Lordship.
can there be? When
Yes,
when
please,
the
Your-
time
I-
of completion is for within 24 months,
I will take, Your Lordship.
2018 to 2024, date of termination,
Yes, Your Lordship.
it spans over 6 months, 6 years.
Yes, Your Lordship. Your Lordship may kindly have, for a second, Your Lordship, page 386, Your Lordship. Page 386, Your Lordship. Just for a
386.
second, Your Lordship. Please, Your Lordship. Page 386, Your Lordship. The really. Your
Yes.
Lordship, Your Lordship, to be filled by the executive engineer, part 3, Your Lordship. At the bottom, Your Lordship.
Yes.
Yes, please, Your Lordship. Now, date of receipt of application in the divisional office, 28th of March 2023. Remarks made at page number 1 of hindrance register. Agree with the SDO's recommendation and EOT of 1675 days on ex gratia basis may be granted for completion of the work. Lordship, now this 1675 days, if we calculate, it will come to Your Lordship on 6th of November 2024, Your Lordship.
What is this? This is a recommendation.
No, Your Lordship, in my contract agreement, Your Lordship, the engineer was the sole authority who will grant the extension of time. Now, the engineer has also misread the contract agreement, Your Lordship. If we see clause of the extension of time, Your Lordship, if my Lordship may kindly see for a second the clause of extension of time. It is only the engineer has the authority to grant extension of time, Your Lordship. Page 152, Your Lordship. Your Lordship, may kindly have page 152.
152.
Please, Your Lordship. Your Lordship, clause 28, Your Lordship. Now, my Lord, extension of the intended completion date, my Lord. The engineer, my Lord, shall extend the intended completion date if a compensation event occurs or a variation is issued which makes it impossible for completion to be achieved by the intended completion date without the contractor taking steps to accelerate the remaining work and would cause the contractor to incur additional costs. So, Your Lordship, the engineer was the sole authority to grant the extension of time, Your Lordship. Now, here, Your Lordship, the engineer has granted recommendation of 1675 days, Your Lordship. It is signed by the signature of executive engineer, Your Lordship. Now thereafter, Your Lordship, the authority, Your Lordship, has issued a show cause notice to me, Your Lordship, on 24th of July 24, Your Lordship. The first show cause notice was issued to me asking as to why the contract should not be terminated under clause 59(2) of the contract agreement. Your Lordship, contract clause 59(2) deals with the termination of contract agreement, Your Lordship. Now, I have given the reply to that notice, Your Lordship, on 27th of July 24, which is at page 415. Your Lordship, now page 415 is my detailed reply to their show cause notice, Your Lordship.
Where's the show cause notice?
Page 414, Your Lordship. It's just a page 414, Your Lordship.
414.
Annexure 8, please, Your Lordship. May I read, Your Lordship, if I allow?
Yes.
Please, Your Lordship. Whereas, on account of your slow progress, expiry of the stipulated time of completion as per agreement, non-compliance of the minutes of meeting held on 11th March 24, and instruction served to you wide letter of 3rd or 30th of April 24 for the work entrusted to you under the agreement and minutes of meeting as referred above, neither the project is not completed within the stipulated date of completion of 31st of December 2023. Not submitted EOT application, and also it appears to me that the project will not be completed during this year 2024. Therefore, I, in exercise of powers conferred on by aforesaid agreements for and on behalf of the Government of Mizoram, hereby give you notice to show cause within 7 days with effect from 24th of July 24 to my satisfaction via an action under 59(2) G and I of the above agreement will not be taken against you on account of the breach of the contract on your part. Now, Your Lordship, to this show cause notice, Your Lordship, I had given a brief, a very elaborate reply, Your Lordship, at page 415, Your Lordship. Your Lordship, if I allow to read, Your Lordship, this is an important letter, my Lord.
Yes.
27th of July 2024 is my reply to their show cause notice, Your Lordship. I'll just read the relevant portions, Your Lordship. Para 2, Your Lordship. At page 416, Your Lordship.
Yes.
So far, we treated the same as normal breach and resolved to perform and execute the work as the applicable law so permits. Therefore, we reached this to the extent, however, hereinafter, we treat the said breach as fundamental breach of contract and request the engineer to communicate a decision within the meaning of 59(3) of the GCC, whether the employer to provide whether the inability of the employer to provide the proper site of the said major bridge amounts to fundamental breach of contract or not. In the said background, the present reply is being submitted and may be treated as preliminary in nature, and further details will be stated in our application for extension of time, which will be submitting shortly. With due respect, we submit that the show cause notice issued under clause 59(2) G and I is not sustainable and is against the true spirit of contract vis-a-vis GCC 44.1. Now, 44.1 is the compensation event, Your Lordship. We do not agree with your unilateral allegation that we have committed slow progress of work, but on the contrary, we would like to respectfully state that when the proposed permanent bridge site is still not available till date, Your Lordship, for further construction work, the question of slow progress does not arise at all. In fact, now we are only executing the works which are beyond the scope of the contract agreement. My Lordship, as I said, Your Lordship, in 2022, they have changed the bridge. Altogether, they have changed the bridge. They have inserted a new bridge
Where?
at the original site, Your Lordship. Now, initially, Your Lordship.
No, how do you say that? Any document to
Yes,
that
yes,
effect?
Your Lordship. I have sufficient documents, Your Lordship. I'll
See,
take on.
what you're saying here is that proposed permanent bridge site is still not made available till date.
Yes, Your Lordship.
How
My
do you
Lord-
how do you say that in the year 2024?
Yes, Your Lordship, I will, Your Lordship, just hear me out, Your Lordship. I will show it from their documents that
No,
the site is not
I'll
available.
hear you out, no doubt, but you just tell me
Yes, Your Lordship,
when the notice to proceed with the work was issued in 2018,
Yes, Your Lordship.
without there being any site, what were you doing? Where were you working?
I was working on whatever piecemeal site available to me, Your Lordship. Whatever made available to me, Your Lordship, initially what has happened, Your Lordship, the bridge, the original bridge was to be constructed, Your Lordship, and for that, a temporary bridge was to be constructed so that the traffic will be diverted to the temporary bridge. for, so that the original bridge will be de-launched or will be deconstructed so that new bridge will be taken over, Your Lordship.
Okay, now you show me where is the clause for that
Your Lordship.
dispute redressal.
Yes, Your Lordship. Now, Your Lordship, I'll read only one letter, Your Lordship, that will convince this court, Your Lordship, that no site was available. And it was their letter, Your Lordship. Your Lordship, may kindly
No,
have
see,
page 397. Your Lordship,
sir-
kindly have page 397. for us.
Surprising thing is that 2018, somebody says you go ahead with the work, and 2024 you're still struggling with this
Yes,
site.
yes, Your Lordship. You see, Your Lordship, that is the
6 years, where were you doing? What were you doing for 6 years?
Your Lordship, whatever site available to me, Your Lordship, I was asked to construct a bridge 18 kilometer from the original site. And I had constructed it, Your Lordship. For that bridge, Your Lordship.
But you have not completed, isn't it?
I had completed that bridge, Your Lordship. Now, Your Lordship, here we are discussing the original bridge, Your Lordship. Now, Your Lordship, may kindly have just page 397, Your Lordship, and it will clear the Your Lordship everything that the site was not available. It is their own letter, Your Lordship. And this letter is signed by the subdivisional officer PWD, Your Lordship. Your Lordship, may kindly have page 397.
Meeting minutes?
Please, Your Lordship. 8th of Feb 2024. Your Lordship, on 8th of Feb 2024, they hold a meeting and they were discussing. Your Lordship, should I read, Your Lordship?
Yes. Why do you want to show me this?
Your Lordship, it will prove that there was no land and there was no fund available. The chairman welcomed the members with warm regards. He expressed the needs and necessities and objectives of the meeting. He stressed the need to tackle various problems arising in the process of finishing the project. He highlighted a few histories of the project and the subsequent progress. In the initial phase of the project, the subway was stationed at Borai and there was a decision to have an SPT bridge at Kanham. This was change of scope item, Your Lordship. This was not the original work, Your Lordship, which was outside the scope of work. This created problem for extra fund. So now a new auto pliable suspension bridge is worked out. Your Lordship, may kindly see the timeline. In 2024, they are working out a new bridge. Auto pliable bridge is worked out, which will reduce the cost significantly. Thereafter, Your Lordship, there will be hurdles on Kanham side for the approach. Now, Your Lordship, in 2024, they were agreeing that yes, there were hurdles towards the approach road of Kanham side, Your Lordship. The problem needs the cooperation of the various stakeholders. The land belongs to P. Mavipui Kanham. The land needed to be borrowed. Your Lordship, the land was not vested with the authority. They were discussing that the land needed to be borrowed for the time being, which is temporary. Additionally, the excavation of the abutment of main bridge on Kanham side might pose some risk on the nearby house during excavation. Now, Your Lordship, 2024, and the houses which was there at the site was not removed by them, Your Lordship.
No, you show me what is the original scope of work.
Please, Your Lordship.
Original scope of work.
Page 136, Your Lordship.
136.
Yes, Your Lordship. It's the contract data, Your Lordship. Your Lordship, you have it?
Yes,
Please, Your
136.
Lordship. Para 8, Your Lordship. The serial number 8, the name and identification number of the contract. Construction of double lane BUSG bridge over our Langaiya on Mizoram Tripura border at Kanham, Mizoram. Identification of the contract, this, Your Lordship. The work consists of these items of works listed in the BOQ. Road work, Your Lordship, and then the bridge and the cross drainage works, Your Lordship. So basically, Your Lordship, my scope of work was only limited to the construction of double lane bridge, Your Lordship. This was in March 2018, Your Lordship. Now, subsequently, Your Lordship, a meeting took place similar to this meeting on 24th of April 2018, Your Lordship, which is at page 207, Your Lordship. Your Lordship, may kindly have page 207. Now, Your Lordship, this meeting took place after the execution of contract agreement between the parties, Your Lordship. Your Lordship, page 207, Your Lordship. Page 207. Now, Your Lordship, this meeting took place when the work was started. Notice to proceed was given, Your Lordship. And this meeting took place on 24th of April 2018. No, Your Lordship. During discussion in the meeting, a meeting is held on 24th of April 2018 in Kanham, Mizoram, in connection with construction of permanent bridge in place of existing Bailey Bridge over river Longai, constructed by PWD Tripura, connecting Damchera from Tripura side and Kanham from Mizoram side. Para 1, Your Lordship. During discussion in the meeting, it is decided that land will be arranged from both the sides by the respective states for construction of bridges and approach. So there was no land available, Your Lordship. Proposed bridge is sanctioned and work already awarded. Drawing and design is yet to be prepared. Drawing and design, Your Lordship, was the responsibility of the authority. A copy of approved drawing and design of said bridge will be supplied to the PWD Tripura by PWD Mizoram. Due to congestion and lack of sufficient space in both sides, construction of subway is not possible near the existing Bailey Bridge. However, a footbridge will be constructed near the existing Bailey Bridge, providing the facility to ply up to auto rickshaws smoothly, as per opinion of village council members of Kanham village, Your Lordship. PWD Mizoram will construct one another subway at suitable place. Double lane bridge class 70R with carriageway excluding footpath will be constructed by the PWD Mizoram at the alignment of existing Bailey Bridge. If there is any side problem or any unforeseen occurrence during construction, the respective officials from both the state will take effort to address the same. Now, Your Lordship, may kindly appreciate this meeting took place after the execution of work. Now, Your Lordship, thereafter, I just, Your Lordship, take Your Lordship to only 2-3 minutes of meeting. Now, Your Lordship, thereafter, again meeting took place on 9th of January 2019, Your Lordship, which is at page 218. Now, Your Lordship, this meeting is almost an year. A meeting took place almost an year after, Your Lordship. Your Lordship, third para, Your Lordship, page 218.
Yes.
Today's meeting was mainly held in connection for finalization and confirmation with the proposed site for the Bailey Bridge subway, finalization of the alignment of the proposed permanent bridge and auto-pliable subway, and also to take stock of the status of the project in pursuance of the decisions and actions taken in the earlier meeting between the two state officials. The main issues were, Your Lordship, may kindly see, main issues: alignment for the permanent bridge site. Your Lordship, alignment is the most fundamental thing to be given by the authority at the very first day. Or, Your Lordship, we were in 9th of January 2019, alignment for the bridge was not finalized. Secondly, Your Lordship, alignment for Bailey Bridge subway. Third is alignment for the foot and auto rickshaw pliable bridge. Fourth, repair and strengthening of the existing Bailey Bridge. And then decisions taken in the meeting, Your Lordship. This is important, Your Lordship. Point number 1, Your Lordship. The alignment for the permanent bridge was fixed by both the PWD state officials, taking the edge of the fish market shed as the benchmark towards upstream, where the edge of the proposed permanent BUG bridge and edge of the fish market, there has to be a gap of 500 mm with allowance of plus minus. So, Your Lordship, there was on 19th of January 2019, at the alignment, there was working fish market, Your Lordship. Now, thereafter, Your Lordship, again a meeting took place on 16th of January 23, Your Lordship. Now, Your Lordship, before that, a letter is important. A letter of 2nd December 22, page, Your Lordship, 329. Your Lordship, this is my letter, Your Lordship, page 329. Your Lordship, may I have it, Your Lordship?
Yes.
2nd December letter, Your Lordship. This is my letter, Your Lordship. I'm reading from para 2nd, Your Lordship. It is pertinent to mention herein, Your Lordship, may I have it?
Yes.
Mention over here that the entire bridge had to be freshly redesigned in view of the reasons stated above, which has resulted in taking huge time and extra cost burdened on us. Now, Your Lordship, may kindly appreciate that initially the original work was for BUSG bridge. Now thereafter, the original bridge was changed to PSC, which is a PSC girder bridge, Your Lordship, which is a pre-casted structure bridge, Your Lordship, in 2022, Your Lordship. Accordingly, the bridge has been changed from built-up steel girder to pre-stressed concrete beam girder to accommodate 1.50 width footpath on each side of the bridge as per IRC. Now, you know, this was all along I was doing on the instructions of the employer. I have no say. I just had to bow down to their wishes, Your Lordship, because I have signed the agreement. My bank guarantees were lying with me. I have no option but to follow their dictates, Your Lordship. Now, Your Lordship, thereafter, there is one letter, Your Lordship, of 16th January 23, page 334, Your Lordship. Not the letter. 1610, Your Lordship, page 374, Your Lordship.
374.
374, sorry, Your Lordship. 374, Your Lordship.
Yes.
Relevant para B, Your Lordship, construction of USG bridge over Langaiya, Your Lordship. The main problem, Your Lordship, causing this project to speed up is that Tripura side demanded for the construction of an auto-pliable bridge, which was not within my scope, Your Lordship, subway of STP bridge near the existing Bailey Bridge before the existing Bailey Bridge is dismantled for construction of abutments. Now a new demand has come, Your Lordship. As the new bridge is aligned in the same location, however, the superintending engineer reported there is no suitable land available for construction near, in or around the bridge, Your Lordship. Now, Your Lordship, this meeting took place in October 2023, Your Lordship. 16th October, Your Lordship. And it is their own minutes, Your Lordship, and it is signed by, Your Lordship, at page 375, signed by Chief Engineer Roads, PWD, Your Lordship. He is the employer, Your Lordship. So they were continuously admitting all along, Your Lordship, they admitted that yes, we do not have land and we do not have fund. Now, lastly, Your Lordship,
What about serial number 4 at page 374?
serial number 4. Yes, so the contractor also agreed to complete launching of subway Bailey Bridge. Yes, this was completed, Your Lordship. Whatever work, Your Lordship, assigned to me, that I had completed, Your Lordship. Your Lordship, the contractor is also sitting here, Your Lordship. The poor man is here, Your Lordship. Whatever work was available to me, I had completed, Your Lordship. This bridge was constructed 18 kilometers, Your Lordship, from the original bridge, Your Lordship. And that was not my scope, Your Lordship, but I had completed it, Your Lordship.
Okay, so what have you not completed now?
What
As per the impugn.
No, coming to their termination letter, Your Lordship. Please, Your Lordship. The termination letter, Your Lordship, is at page
458.
458. Please, Your Lordship. Now, Your Lordship, if Your Lordship may kindly turn to page 463, Your Lordship. I have enclosed the photographs of the present situation, prevailing situation of the site, Your Lordship. The photograph is dated.
No, don't take me to photograph.
Okay,
now.
please.
You just show me what is
Termination. Please.
What is said in the termination letter?
Yes, Your Lordship. Page 458, Your Lordship.
Yes.
Please, Your Lordship. Whereas, under clause 59.2 of condition of contract, in the contract agreement for construction of double lane USG bridge over Langaiya on Mizoram Tripura border, the engineer in charge shall have powers to take action under clause 59.2 in the event of delayed completion of work by the number of days for which the maximum amount of liquidated damages can be paid as defined in the contract data and fails to provide insurance cover as required under clause 13.1 by the contractor, so that in the opinion of the engineer in charge, which shall be final and binding, you will be unable to secure completion of work by the stipulated, have already failed to complete the work by the stipulated extended date of completion. Whereas you have delayed, suspended the execution of the aforesaid work, and as per the opinion of the undersigned, the engineer in charge, which is final and binding, you will be unable to secure completion of the work by the stipulated, have already failed to complete the work by the extended date of completion, and whereas you were served with a show cause in this regard under this letter of 24th of July 24, your reply received on 27th 24, received in response to show cause, has been considered carefully but not found to the satisfaction of the engineer in charge. That was the sole reason, Your Lordship. Due to this, a reminder for show cause notice was reserved under this office of letter dated 24th of August 24, but no reply has been given by you so far within the given time. So, Your Lordship, I had already given the reply, Your Lordship, to their first show cause notice. So, there is no question of again replying to the same show cause notice, Your Lordship.
No, it's not the same.
The same, exactly same, Your Lordship.
No, the second show cause notice.
Yes, it is exactly the same, Your Lordship.
Maybe. You could have said that what I had stated earlier, this will be my reply to your second show cause also.
Yes, Your Lordship. I agree, Your Lordship. It can be, Your Lordship, but nothing has been changed on ground, Your Lordship. Nothing has been changed, Your Lordship. Your Lordship, may kindly see my reply to their first show cause notice.
No.
It is,
Please continue.
please, Your Lordship.
Which is found
Which
unfortunate.
is found unfortunate and discouraging by the engineer in charge. Therefore, under powers delegated to me under subclause 59.2 G and I, Lal Zarliana, Chief Engineer, wrote for the aforesaid work under the aforesaid agreement for and behalf of the Government of Mizoram, hereby determine the contract as aforesaid, upon which determination your earnest money deposit, security deposit already recovered and performance guarantee stand absolutely forfeited to the government and shall be absolutely at the disposal of government. Take out such part of the work out of your hand as remain unexecuted for giving it to another contractor to complete the work, and you shall have no claim to compensation for any loss sustained by you by reason of your having purchased. Your Lordship, thereafter, at the last para, Your Lordship, page 459, you shall not be allowed to participate in the tendering process for the balance work, Your Lordship. So they have stopped me, prohibited me. Now, Your Lordship, may kindly appreciate that this termination letter was issued on my alleged failure failure to comply with clause 59.2 G, I and G of the contract agreement, Your Lordship. Now, Your Lordship, I will demonstrate without going to the merits of the dispute that these clauses cannot be invoked, Your Lordship. Now, Your Lordship, come to clause 59.2, Your Lordship. Clause 59 is, Your Lordship, is at page 161, Your Lordship. Page 161, Your Lordship.
59.2 G.
Your Lordship, termination, Your Lordship. G is, Your Lordship, the contractor has delayed the completions of works by the number of days for which the maximum amount of liquidated damages can be paid as defined in the contract data. So, Your Lordship, as per them, I have delayed the work, Your Lordship, because of which the liquidated damages has exceeded the limit. Now, Your Lordship, the limit for liquidated damages under the contract agreement was 10% of the original contract price, which comes to, Your Lordship, 2 crores, Your Lordship. So that if the authority has levied a damages amount of more than 2 crores, Your Lordship, then they are entitled to terminate this contract agreement. But, Your Lordship, as I had narrated, Your Lordship, the engineer had already recommended the extension of time to me for 1675 days, which were to be concluding in November 2024. Now, Your Lordship, since engineer has already granted me the delays, the extension of time, how does it operate this clause, Your Lordship? Now, the delays were granted to me for the delays attributable to them, Your Lordship. Now, on the contrary, they are operating under this clause, Your Lordship. This clause cannot be operated, Your Lordship, because I have the extension of time till November 2024, Your Lordship. Now, since I have the extension of time, this clause becomes inoperable, Your Lordship. Now, the second clause, Your Lordship, I, Your Lordship, is at page 161, Your Lordship. Now, I says, Your Lordship, the contractor fails to provide insurance cover as required under clause 13.1, Your Lordship. Your Lordship, clause 13.1. So this clause I has to be read in conjunction with clause 13.1, Your Lordship. Your Lordship, clause 13.1 is at page, Your Lordship, 149. Lordship, may I have it, Your Lordship? Page 149, Your Lordship. Your Lordship. The relevant is, Your Lordship, 13.3, Your Lordship. Clause 13.3, Your Lordship. If the contractor does not provide any of the policies and certificates required, the employer may affect the insurance which the contractor should have provided and recover the premiums the employer has paid from payments otherwise due to the contractor. So, Your Lordship, this clause clearly says that if even in the event I failed to affect the insurance, the employer will do the insurance and recover the money from my bills, Your Lordship. Now, therefore, Your Lordship, this cannot be treated as fundamental breach, Your Lordship. Now, be that as it may, Your Lordship, I had already submitted the insurance on 12th of September 2024, Your Lordship.
See, the termination says 13.1. You read 13.3.
13.1, Your Lordship. The contractor shall provide in the joint name of the employer and the contractor insurance cover from the start date to the end of the defect liability period in the amounts and deductibles stated in the contract data for the following events which are due to the contractor's risk. So, Your Lordship, now it only says that I have to give them the insurance cover, Your Lordship. Now similarly, Your Lordship, this clause has to be read in conjunction with 13.3, Your Lordship, that even if I fail to give insurance cover, the employer may affect the insurance and recover it from my premiums, Your Lordship. So this will not constitute it will constitute a default, Your Lordship. I agree, yes. My failure to give insurance will constitute a default, but it will not constitute a default which was fundamental in nature and which have materially adversely affect the contract, which will entitle the employer to terminate the contract agreement, Your Lordship. No, Your Lordship, in fact, Your Lordship, to the contrary, Your Lordship, may kindly have page 427. Page 427, Your Lordship.
427.
Please, Your Lordship. Now, at page 427, Your Lordship, I had enclosed the insurance cover policy, Your Lordship. And it is dated 11th of September 24, my Lord. Lord, may I have it?
Yes.
Please, my Lord. Now, my Lord, page 427, my Lord, at the right, Your Lordship, date is 11 September 2024, Your Lordship. So this insurance policy I had already given to them on 11th of September 2024, Your Lordship. No, Your Lordship, therefore the termination on this ground does not hold, Your Lordship. I had already given them the insurance policy, Your Lordship.
What is this insurance for?
It is car policy, Your Lordship. Your Lordship, generally, it is insurance policy towards all the work, Your Lordship. Whatever work which was executed at the site, I am supposed to insure that work, Your Lordship. So it is in regard to that, Your Lordship. Page 432, Your Lordship.
What is the premium?
Premium,
51,000.
I'll have to confirm, Your Lordship. Premium is 51,000, Your Lordship. Please, Your Lordship. Now, Your Lordship, Your Lordship may see the amount. For 51,000, even if I had not taken the insurance policy, Your Lordship, for 51,000, they had terminated my contract agreement, which I had tried to do it from 2018, Your Lordship.
The entire work which you have executed so far is sufficient to be covered by insurance premium of 51,000.
No, Your Lordship. This was the premium. The sum assured, Your Lordship, is at page 428, Your Lordship.
No, premium means the amount which you pay
Yes, Your Lordship.
for subscribing the insurance
Yes,
policy.
Your Lord. For 6 months, Your Lordship. It is for 6 months, Your Lordship.
So how does the insurance work?
Your Lordship, that I need to ask from my client, Your Lordship, regarding
No, the purpose of insurance is in case of any eventuality, some damages or something happens,
Yes, Your Lordship.
then whatever amount which you had insured for will be recovered
Yes, Your Lordship.
through this insurance company.
Yes, Your Lordship.
So that is why the premium seems to be quite on the lower side.
No, Your Lordship, but that has not been made part of the termination agreement. The termination agreement, if you see, was only given in the most mechanical manner, Your Lordship.
No. Leaving aside your termination part, I'm asking you generally,
Yes, Your Lordship.
when you insure, like you have your car insurance,
Yes, Your Lordship.
if it's a third party, money is something.
Yes, Your
If it's the entire, what do you call, what is that other policy? Wherein you insure your car.
The insurance policy, Your Lordship, car insurance policy. So, Your Lordship, for that we will pay the insurance, and if an amount will be insured, Your Lordship. Similar, the same is in this case, Your Lordship.
And page 428 is sum insured or sum assured?
Page 428 is sum insured, Your Lordship.
How can that be? It shouldn't be sum assured.
It is 220 crores.
What did you insure? The work that you have done.
Yes, Your Lordship. No. Permanent and temporary, including all materials, all the work, Your Lordship. Yes, Your Lordship. Nature of project, material, insured items, Your Lordship. If we see page 428, at the table, contract works, permanent and temporary, including all materials to be incorporated therein. That means all work, Your Lordship. Contract price, materials or items supplied by the principal, and any other source installation not included in one and above.
Okay. How did you supply this insurance?
I had, Your Lordship, WhatsApp, Your Lordship.
By WhatsApp.
Your Lordship, surprisingly, I have received the termination letter only on WhatsApp. Surprisingly, Your Lordship, all the correspondences.
You have also given on WhatsApp. You got back WhatsApp.
No, Your Lordship. No, Your Lordship, that was generally the mode of communication. I actually asked my client that how are you communicating? They said we communicate only on WhatsApp. That is a very pertinent question, Your Lordship, but it is, Your Lordship. At page 426 is the WhatsApp screenshot, Your Lordship.
This final notice also is by WhatsApp.
Yes, Your Lordship. I have not received a notice or a copy of termination on email or on post. It is only through WhatsApp, Your Lordship. Now, Your Lordship, in this context, Your Lordship, the contract agreement provides for the appointment of a dispute review expert, Your Lordship, under clause 25, Your Lordship.
Where is that page?
Page, Your Lordship.
Clause
Page
25.
150, Your Lordship.
Clause 25.
Please, Your Lordship. Start with clause 24, Your Lordship. Page 150. Your Lordship may have it?
Yes.
24.1, Your Lordship. If the contractor believes that a decision taken by the engineer was either outside the authority given to the engineer by the contract or that the decision was wrongly taken, the decision shall be referred to the dispute review expert within 14 days of the notification of the engineer's decision. Now, Your Lordship, thereafter, clause 25 provides for procedure of dispute.
Who is this? What is the composition of this dispute
Your
review
Lordship,
expert?
unfortunately, there is no dispute review expert. Despite my request, they have not appointed dispute review expert.
What is the composition otherwise? It is to be appointed.
Yes, Your Lordship, page 135, Your Lordship. Your Lordship, page 135. Contract data, Your Lordship. Para 3, Your Lordship, serial number 3. Serial number 3, Your Lordship, dispute review expert appointed by the employer to be appointed.
What is this?
This is dispute review expert, Your Lordship.
No, this document.
Contract data, Your
Contract that data.
Your Lordship. Now, Your Lordship, at page 137, Your Lordship, Chief Engineer is the appointing authority of the dispute review expert, Your Lordship. At page 137, serial number 20, Your Lordship.
Serial number
20, Your Lordship.
20.
Appointing authority for the dispute review expert. Chief Engineer roles.
This will comprise of how many members?
Single member, Your Lordship.
Huh?
Single, Your Lordship.
Single member.
Yes, single. Only one member, Your Lordship. And
Now, after this, after receiving this impugned notice,
please, Your Lordship.
have you submitted any representation?
Yes, Lordship, I have replied to their letter, Your Lordship. My reply is dated,
23/9
yes, Your Lordship.
itself?
Yes, Your Lord, please, Your Lordship. At page 460, Your Lordship, I've given a short reply to their termination notice, Your Lordship. Your Lordship may have page 416, para 2, Your Lordship. At the outset, the termination notice of the employer is not maintainable as the same is illegal and in contravention of the contract agreement. The employer are in breach of contract agreement expressly mentioned in the contract as compensation events and various delays which is still continuing till date and are not attributable to the contractor, thereby resulting the contract time set at large. And on the contrary, to cover up their lapses, the employers are aware of clause 59.2 of the contract agreement stipulates that only upon occurrence of a fundamental breach, the employer becomes entitled to issue the termination notice. A bare perusal of the alleged termination notice, it is evident that the employer in its alleged termination letter has failed to substantiate out any fundamental breach on part of the contractor, and the letter is issued in a mechanical manner, ignoring the factual ground realities. It is noted with utmost dismay that despite the contractor having complied with its obligation and despite the continuing delay in handing over of site and other breaches, the contractor has been continuously executing the project. Whereas, on the contrary, the employer have miserably failed to perform its obligations, more so at this juncture when the contractor has satisfactorily replied to engineer's show cause notice of 24 July 2024, calling upon the employer to immediately cure various defaults, breaches pointed out in the said letter, which the employer and the engineer have conveniently bypassed. Contents of the said reply dated 27th July should be read as part and parcel of the present reply. Regrettably, without considering the aforesaid, the employer in a mechanical and predetermined manner has chosen to issue the alleged termination, which even otherwise is illegal. Now, Your Lordship, therefore, I requested them to withdraw the termination letter. I had also pursued them, Your Lordship. I had used my good offices. I had visited them, Your Lordship, tried to convince them to withdraw the termination letter, Your Lordship, because I had already heavily mobilized at the site, Your Lordship.
Okay, what about the next page? You have asked for 7 more days
Yes, Your Lordship.
to do the measurement.
Your Lordship. Lordship, in fact, nothing has come from their side. They have not.
What happened after that? After your
No,
representation?
they have not replied, Your Lordship, to this.
They have not
letter.
replied.
They have not replied. Your Lordship.
Measurement has been carried out?
No, Your Lordship. Measurements are also not carried out, Your Lordship.
How do you say that?
Your Lordship, because they have never called me up, Your Lordship. Or they might have done so on their own, Your Lordship. I have no knowledge, Your Lordship. Because they have not communicated to me whether they have.
See,
done
the
measurement.
notice says that
Notice
measurement
that-
will be done on
Yes.
24/9.
Yes, Your Lordship.
If you do not come, it will be done within your absence also.
Yes, Your Lordship. So Your
They have
Lordship,
done it.
they must have. Maybe, Your Lordship. No? No, it is not with letter. They might have, Your Lordship. No, Your Lordship.
Then what is your statement? Where is your statement in the writ petition that despite this, they have not taken any measurement?
No, Your Lordship, it is not about the measurements, Your Lordship. Measurements, Your Lordship, is the
No.
secondary part, Your
This is
Lordship.
the question. You see, don't shy away from the question. If you have not written anything, just say so.
Yes, Your Lordship. I am very honestly, Your Lordship. I will concede that point, Your Lordship. I know, Your Lordship. I will not
See, rightly or wrongly, they say that enough is enough. You please stop this work.
Yes.
Remaining balance, we'll get it done by somebody.
Yes, they had-
And whatever amount of work you have done, we'll have a measurement on this date.
Yes, yes.
Please come.
Yes,
If you don't come,
They-
we'll proceed with the
they'll proceed
measurement
with it. Yes.
without you also.
Yes, yes, Your Lordship.
You have written one reply saying that please cancel this order because I have done so many things, so and so and so and so. And below, you have also made one request.
Yes, yes, Your
Please postpone it for another 7 days.
Yes, yes, yes.
Because all my engineers and my workers, they have gone somewhere else. So my specific question was that, what has happened to that? You said that there's no reply.
Yes, yes.
And whether measurement has been taken, you say yes, or sometimes you say no.
Your Lordship, to be very honest, Your Lordship, as a lawyer, Your Lordship, since I have no knowledge, so I can't comment on it, Your Lordship. I can concede to that effect, Your Lordship, though my client is saying no. But I have no knowledge, Your Lordship, to be very, very honest, Your Lordship, whether measurement has been taken place or not, Your Lordship.
See, your knowledge is not required here. Only thing is that the instructions you get from your client, you need to put down in the pleadings.
But Your Lordship, in my respectful submission, Your Lordship.
It should be yes or no. It cannot be in the middle.
Yes, yes, I agree.
It may be, may not be, maybe may not be.
Yes, yes.
How
Your
can
Lordship.
that be?
But Your Lordship, that merely me not participating in the measurements will not, Your Lordship, absolve them from their obligations under the contract agreement, Your Lordship. No, Your Lordship, I have demonstrated
So
that.
what is your prayer then?
No, Your Lordship, no, Your Lordship, my simple prayer, Your Lordship.
To appoint some dispute review expert?
Yes, Your Lordship. So
Let them
that,
appoint.
so Your Lordship, so that he will decide the matter within 28 days, Your Lordship. And in the meanwhile, Your Lordship, they have.
28 days.
Your Lordship,
There's a
and-
clause here.
Yes, yes, Your Lordship.
Okay.
So he has to give the decision within 28 days, Your Lordship. And now, Your Lordship, because I am willing to work, Your Lordship. And now, Your Lordship, in the meantime, since they have already notified the tender for the balance work, Your Lordship, which
Where?
for the I swear, Your Lordship.
Where's the notification?
Your Lordship, page, Your Lordship, 473A.
Huh?
Page 473A, Your Lordship. And Your Lordship, it is para 2, Your Lordship. Name of-
473A.
Yes, please. Your
This
Lordship.
April.
No, Your Lordship, 27th of September 20, it's a 473A, Your Lordship?
This is dated 26th April 2023.
No, Your Lordship.
Oh.
Your Lordship, it's the second last page of the petition, Your Lordship.
470.
3A, Your Lordship.
Second last page.
Please, Your Lordship.
Serial number, paragraph number, what?
Serial number 1, Your Lordship. It is, the heading is invitation for bids, open tender.
No, something wrong. My
Please.
473A is non-appointment of dispute review expert.
I think there's some pagination issue, Your Lordship.
Something wrong with the pagination.
Yes, yes, yes. Can I give my petition, Your Lordship?
No, you please have a look at my petition and
Please.
see.
Please, Your Lordship.
You said 473A.
Yes, yes.
Just see what is here in 473A. This is not what you said.
Please, Your Lordship. My apologies, Your Lordship. I'm troubling Your Lordship. I'm taking.
That is why normally we should have it listed. You all pressed for unlisted. Somehow we have allowed. 463A, look at that page. This is dated 2023.
Your Lordship, the papers have been mixed up.
What is the page?
462A, my lord.
Wow, 62. But it is different in your copy.
Yes, yes. My page number is 473A, Your Lordship. Your Lordship, name of work, Your Lordship.
Completion of balance
Completion
work.
of balance work, Your Lordship.
Now, what is the last date?
Construction of double lane. The last date is tomorrow, Your Lordship. 22nd. The para 3, Your Lordship, bid shall be submitted in the office of the chief
Today is
engineer.
what date? 16.
12th noon, 22nd October, and will be opened on 22nd October. Para 3, Your Lordship.
Where? Para 3.
Yes, please, Your Lordship. And this notice inviting tender was not given online, Your Lordship. It was not published online. Generally, their practice is they will invite all NITs via online through internet, Your Lordship. But this was not posted online.
This is dated 27 September.
Please, Your Lordship.
You have come after so many
Your
days.
Lordship, unfortunately, Your Lordship, they have not posted this online. So I got to know only before holidays, Your Lordship. So
No.
as soon as I noticed, Your Lordship, I have come before
That
Your
is
Lordship.
there, no doubt. But the thing is that since you have received that notice of termination,
Please,
then you should have straight away come.
Your Lordship,
You were told.
my party, Your Lordship, they were trying to get back the work, Your Lordship. He is more than willing to execute this work, Your Lordship. He has already invested huge amounts. Actually, Your Lordship, the bank guarantees which he has acquired, Your Lordship, is after hypothecation of his ancestral land, Your Lordship. So he has heavily invested now under severe debt, Your Lordship. So he is tried very hard to convince them to terminate the letter, Your Lordship.
See, these are matters, you're not a beginner or something. You are a professional. In contract and tender matters, there are risks. And you have taken this job seeing the ground condition that you will be able to work. All these factors are there, you see.
These are there, Your Lordship. But Your Lordship,
Contract.
otherwise, Your Lordship, what is the point of having all these clauses in the contract agreement? Your Lordship, under 20, as per clause 21, they have to give me site from the day on which the work is to be proceeded, Your Lordship.
You never complained.
They never complied.
You never complained.
No, Your Lordship. They were.
2018 onwards, you've been carrying on till
Your
2024.
Lordship, I had no option, Your
You
Lordship.
still are not work.
No,
You
Your
have
Lordship,
still
I
not
had no
completed.
option but to follow their terms, Your Lordship. My bank guarantees are with them, Your Lordship. So I had no option but to execute the
There
work.
must be some conditions of contract wherein some sort of relief can be given to you if such kind of situation
Your Lordship,
arises.
only through DRE. And DRE they have not appointed. Now the contract provides for appointment of DRE so that I can raise my dispute and take my disputes to the DRE.
You have participated all along. Till now, you have participated.
Your Lordship, because I want to complete the work, Your Lordship.
But you're not completing the work also.
No, Your Lordship, Your Lordship, whatever best, Your Lordship, may kindly just see the photographs, Your Lordship. May takes a second, Your Lordship. Just see the photographs, Your Lordship. May kindly just have a look at the
No,
photographs.
it's okay. Not required. Yes, Ms. Nunlui, what do you say? You are there? Have you received any instructions in this? Can you get the instructions by tomorrow, 10:30? Question is, you see, why I'm asking you this, because they say that this proceeding should be stayed. You have understood, I think, the entire grievances projected. Some construction of bridge was required. Beyond the scope, they kept on modifying it. Ultimately, land also was not available, and ultimately, some notice was given, and now they say that you stop the work and we'll get it done by somebody else. Party has already invested so much, and the two clauses have been invoked here, which perhaps may not be relevant prima facie. But then, in the meantime, the department has proceeded to go for the completion of the work by again retendering it. Tomorrow they are going to open at 2 o'clock. So this is regarding interim order. Now there's a provision here which says that dispute review expert can be appointed, which is supposed to complete the exercise of reviewing or whatever within a period of, say, 28 days.
28 days, Your Lordship.
That has not been appointed. That authority can be appointed by the chief engineer as per the conditions of contract. This all depends on your submission. What do you say? They have to brief you, not you brief them.
Yes, sir, I mean.
They have to brief you. They already know what they're doing. They know what they're doing. They have done all these things. Now, the petitioner has come to challenge this before the court. So you have to justify your actions, that's all. And we cannot straight away dispose it off like that without hearing you or the respondents. But since they are going for the interim prayer, so court may grant you time till tomorrow, 10:30, to come up with the instruction. Then we'll take a call how to go about it. Mr. Counsel, tomorrow,
Please, Your Lordship.
please write down. This matter has been listed. No. Please rewrite. This matter has been taken up as an unlisted motion on a mention made by the learned counsel for the petitioner. To stop. The grievance of the petitioner is to the issuance of notice on final action under clause 59.2 of condition of contract in the contract agreement dated 27/3/2018 for construction of double lane BUSG bridge over R. Lankai on Mizoram-Tripura border at Kanmun, Mizoram. You'll get it at page 458. 458. Stop. According to the petitioner, clause 59.2 bracket small g and bracket small I has been invoked, which otherwise is not relevant or attracted to terminate the work carried out by the petitioner. To stop. The further grievance of the petitioner is that the respondent authority concerned is required to appoint a dispute review expert in order to look into the dispute raised, and who is required to make a resolution, take a decision within a period of 28 days. Stop. Because of the aforesaid reasons, according to the petitioners, the impugned notice on final action dated 23/9/2024 should be set aside. Stop. Further, the petitioner prays for a direction to the respondents from taking any coercive steps pursuant to the notice dated 23/9/2024, and also to stay the invitation for bids (IFB) open tender dated 27/9/2024, which is scheduled to be opened on 22/10/2024 at 1400 hours. Next para. Considering the above projection and in view of the urgency in the nature of the case, Ms. Lal Nundui, learned government advocate, shall obtain necessary instructions by tomorrow. That is the date. Keep the date.
22nd, Your Lordship.
22/10/2024. Specifically, in respect of the dispute review expert appointment, and also in respect of the invitation for bids IFB open tender dated 27/9/2024, scheduled to be opened tomorrow, as stated herein above. Stop list the matter again tomorrow in the motion column.
Seeking your lordship indulgence, I would like to ask your lordship if I may be allowed to rearrange the annexures that I have misplaced, my lord.
It's here.
Yes, that's page number 472 and the page number 4.
Everything is here, but it's only mixed up.
Yes, yes, my lord.
You can give
Much obliged.
both the copies, and you make sure that their copies are also same.
The rest is the same, my lord.
The government advocate's copy.
Yes, my lord.
It's okay.
Yes, my lord.
Okay.
Daily list for admission, item numbers 1 and 2.
May it please your lordship.
Yes.
Your lordship, I have three prayers here. One is to release the deducted 10% cess to the petitioner. And number two is interest in terms of section 80 of the right to fair compensation and transparency in land acquisition. And number three is market value of the lands of the petitioner's suit be enhanced, and or the state respondent directed the state respondent to appoint the appropriate authority for reference court.
Okay, how many petitioners are here?
They are 74.
In one case, 74, in one
Yeah.
case, 7.
7, yes.
And where is the land location?
The land location is Siha district, Lucky,
Polso to Tongkolong.
Tongkolong,
Polso to Tongkolong in
Yeah.
Siha district.
Siha district, DRTF road.
The other one is also
The same. The other one is B Junction and 6 others.
Polso to Tongkolong.
Yeah, same.
So, land was acquired for Purpose of construction of road,
Yes, BRTF road.
BRTF road.
Yes.
Which year was it acquired?
Acquisition process is after filing a case before this honorable court, only they have a issue notification. In fact, the construction is taken in the year 2007
Okay.
and
Without acquiring.
without acquiring.
And when was the notification issued?
Notification is issued in the year 2018 only.
Which case you want to take up first? The
First, 73, Zohoi Liana and 70.
73.
Yes, this
Okay.
is the main.
73.
WPC number 60 of 2023. Zohoi Liana and 73 others.
60. Okay.
Yeah.
You are saying that road construction started in 2007.
Yes,
Acquisition or notification was only issued in 2018.
18.
But it's 2013 as per your statement.
Yeah, 13 is for others. This 2013 is 0 to 20. Our land is located in 20 to 30. Kindly see the Annex 3, Your Lordship, the history of this case can be seen. Award number 5 of 2020. Annex 3, page 50. Lordship got it.
Yes.
Here introduction, whereas the land is required by the government for public purpose for construction of Kolso Pura Tongkolong Road, 20 to 30 km in Siha District, Mizoram, and that for the said purpose, the Secretary to the Government of Mizoram Land Revenue and Settlement Department, in compliance of the Honorable High Court order dated 2/5/2018, in WC such and such, has issued preliminary notification under Section 11(1) of the right to fair compensation and transparency in land acquisition, dated 13/8/2018, and wherein the government appoints Deputy Commissioner, Collector of Siha District under Section 12 of the said Act to perform the function of a collector for the proceeding. Whereas the Deputy Commissioner, Collector, Siha District, in pursuance of the said notification, has issued public notice via memo such and such 31/8/2018, which was published in 2 leading local newspaper, and a copy of the public notification was forwarded to all concerned village councils on the stretch of the road. It's important to read out the whole thing, Your Lordship, the
See,
history. Yeah.
History started from WPC 53 of 2017.
It will come here. They have mentioned that.
This is the second round.
Yeah, this is third round.
Third round.
The WPC is.
What is the first writ petition?
A writ petition is, I have mentioned that, in fact, Your Lordship, without acquisition, without following the Land Acquisition Act, they have possessed my land and they are given us damage.
Okay, what is
Yes.
the first writ petition? WPC
First
number?
writ petition is WPC
53?
160 of 2016, and second
160,
160
2016.
16, and number second WPC is 224 oblique 2016.
Disposed on?
This is kindly see the judgment here, Annex 2.
Disposed of by common judgment?
No, different.
or separate?
We have approached second time, and this is the third time. The same issue. Page 45 is judgment and order.
Annexure 2 is page WPC
It starts
53.
from, yeah, it starts from,
Annexure 2 is,
it
Annexure
starts
2
from
is,
37, but the
this is WPC 53.
53, here it's written the previous case. Para 2 of this judgment, it's mentioned here. Page 45, para 2. You got it, Lordship? The petition's case in brief is that the BRTF had constructed a road through the lands of petitioners as no compensation was paid to them for acquisition of the same. Petitioner filed such and such. This was disposed of the above to read petition by such and such, directing the respondent to conduct a spot verification of the petition lands covered by the respective garden paths. This court also directed that if it was found that the road had been constructed over the petitioner lands, a supplementary award should be made for acquisition of their land. And after this passing the two cases, they have not yet made a notification regarding lands. And they have only made 0 to 20. In fact, R is 20 to 30 stretch. And we have approached this Honorable Court again in this case, WPC 53 of 2027, wherein here again directed from the para 8, Lordship, page 47. Para 8, the basic question to be determined is whether the road constructed by the BRTF, that is called Pura Tongkolong Road, passes through the lands of the petitioners, and if so, whether petitioners are entitled to be paid compensation for the same. The court had earlier passed orders such and such, directing the respondent to make a spot verification of the petition land and verify whether the road was constructed over the lands of the petitioners. The validity of petitioners' land passes were also to be looked into. The Joint Verification Report 2012-2016 and 7/2/2017 made in pursuance to the above two orders of this court show that the lands of petitioners are located allegedly between 20 to 30 kilometers of the Kolcho Pura Tongkolong Road. As per article such and such, no person can be deprived of his property save by authority of law as per the Land Acquisition Act applicable. Just because the petitioner lands do not lie between 0 to 20 kilometers does not mean that the petitioners are not entitled to payment of any compensation if the road actually runs through their lands. Accordingly, in view of the above reasons, the petitioners are directed to constitute a fresh verification team who shall conduct a spot verification of the lands of the petitioners and verify whether the Kolcho Pura Tongkolong Road constructed by the BRTF runs through their lands. If it is found that the road runs through the lands of the petitioners, the state respondents shall initiate land acquisition proceeding for the portion of lands which they intend to acquire. Though the state government have initiated acquisition proceedings under the Mizoram Land Acquisition Act 2016, the same cannot be applied to the present case in view of the judgment and order passed in such and such, wherein this court has held that the Mizoram Land Acquisition, Rehabilitation and Resettlement, etc. 2016 is not applicable in the state of Mizoram, and that acquisition of land will have to be made as per the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. The respondents are reminded of the fact that they cannot deny compensation to the petitioners only on the ground that their lands do not fall within 0 to 20 kilometers as long as the road constructed by the BRTF runs through the lands of the petitioners. Even if it is beyond 20 kilometers, compensation for acquisition of portion of or whole of the affected land will have to be paid by the respondent by following the provision of right to fair compensation and transparency in Land Acquisition Rehabilitation and Resettlement Act 2013. In the event the respondent want to vacate the lands of petitioners, assuming the road has been built upon it, the respondent will have to pay for damages caused to the lands. Either way, the question of payment for compensation for acquisition or damages will have to be decided by the respondents, as it will be subject to the spot verification to be conducted to ascertain whether the road runs through the petitioner's land. The verification team to be constituted will consist of representative of the Deputy Commissioner's Office, BRTF, Revenue Department, MADC, and the petitioners. The verification team shall be headed by the Deputy Commissioner, District Collector, Siaha. The entire exercise from spot verification till completion of acquisition proceedings or payment for damage caused to the land shall be concluded within the period of 6 months from the land of receipt of the certified copy of this order. With
Okay, see, the petitioners in this WPC 53 are also the petitioners in the present writ petition.
yeah, right,
This is WPC 60.
yes.
Same petitioners.
This is WPC 53. Yes, the one I read out is 53.
Yes, 53.
And they are same in the previous two cases, same petitioners.
In the previous
See-
two cases means?
Yeah, 60 and 60 of 2016 and 224/2016. They are same petition.
Okay, initially 160 of 2016 was
Yes.
filed.
Yeah,
Thereafter, 224 of 2016 was filed. So assessment was made or verification was done, but the case of the petitioners was left out
yes.
because it did not fall within 0 to 20 kilometers.
Right, right,
Your land falls beyond 20 kilometers,
Yes,
20 to
yes.
30.
right. That's
So-
why we have approached
So,
again.
court said that even if your land falls beyond 20 to 30,
Yes,
beyond 20 kilometers, still it should be verified and they should be given compensation
Right.
under the 2013 Act.
right.
Correct? So this is the order.
This is the order.
Then after this order, what happened?
After this order, award number 5 of 2020, Annex 3,
Page 50.
page 50.
This was prepared.
Prepared,
Award number 5.
5 of 2020.
Okay. Now, what
where-
was given here? You do not receive any compensation.
I have received.
Then?
Now I approach this honorable court to release cess.
Release
deducted-
cess.
Yeah,
Not only says, you were saying something else
yeah,
also.
yeah, interest,
Interest on?
delay payment,
Interest on delayed payment.
yes.
Under what provision?
Under section 80 of the
2013 Act.
Yeah, 2013 Act.
2013 Act. So, you were also saying about something about enhancement of the value, market value.
Yeah, yes. That also, the thing is that the state respondent should have been constitute reference court. But till date, Siha district, there is no reference court. So that's why I have approached this honorable court to exercise extrajudicial power. With
Reference
regard-
code under what section?
Section 2013, 50, section 52.
Composition of authority.
Yeah. Shall consist of one person only hereinafter presiding officer to be appointed by notification by the appropriate government.
This is like a reference code under section 18.
Yeah, right, like that, yes. And this 64 here, the way, reference to authority. Kindly see 64, Your Lordship.
The authority is 52, composition,
Yes, composition.
and 64 is the reference.
Reference to authority, yeah.
Reference by
Any
whom?
person interested who has not accepted the award may, by written application to collector. Collector has to refer the said application within 30 days to the reference court. So there is no reference court. You have filed RTI and they have answered that they have not constituted any reference court in the district of Siaha.
Cess has been deducted under what provision?
Under section MADC, kindly see page from para 6, Your Lordship, my statement, page 19, that the respondent authority under the MADC had deducted 10% of the compensation award as cess by invoking Section 23(2) of the Mara Autonomous District Council Land and Revenue Act 2018, as well as the notification dated 23/9/2019, which was made in exercise of Section 23(2) of the MADC Land and Revenue Act 2018, notifying that the MADC shall collect and levy revenue cess to the extent of 10% from any land holding from the value of the land on any other ground, etc., with effect from 19/9/2019. That Section 23(2) of the State Act is produced below, Your Lordship. 23(2), in exercise of the power vested to it by subsection 1 of this section and subject to the provision of Section 22 of this Act, the Executive Committee or concerned authority shall be competent by public notification or by official order to collect revenue from any land pass holder as it may deem fit and reasonable, to collect and levy cess to the extent of 15% or cost or charge which may be increased or decreased, and fixed by the Executive Committee from time to time by a official order or notification from any land holder from the value of the land and on any other ground and in the manner as may be prescribed from time to time for the conduct of spot verification, survey, measurement, or any other administrative work or otherwise as provided and envisaged under subsection 1 of Section 22 of this Act on certain and special occasions as case may be, to collect such fees, costs, or charges for mutation from any land or pass holder, to exempt certain land pass holder from payment of revenue or other charges or sufficient and reasonable ground. So on this basis, 10% cess is deducted. And my contention is that, Your Lordship, even the state of Mizoram also made some notification regarding revenue department make some deduction.
See, you said 10%,
Yes,
but your reproduction of section 23(2) is about 15%.
which may be decreased or increased. So they have taken 10% only here.
Notification 23/9/2019
Yes,
provides for 15% cess,
yes.
but you say that 10% has been deducted.
Yes,
Isn't
here
it?
they, which may be increased or decreased. They have written B, Your Lordship.
Yes, but is there any such notification increasing or decreasing it?
No,
Is it
nothing,
not-
nothing. 20,
Is it required or not? They can
20,
They can
kindly-
collect-
Yes,
or levy cess up to the extent of 15%.
it seems that, Your Lordship.
So if they
Kindly-
decide To take less.
Yes. Yeah, here they have notification, Annexure 6, Your Lordship,
Page?
page 68. Here they have mentioned 10% from any landholders.
No, it says 10%.
Yes.
But you have abstracted this 23 to here.
Yeah, this notification is mm,
Okay, now I got it.
yes,
23 to provides about this levying of cess
yes,
up to
levying
15%.
yes,
Now, by this notification of 23/9,
yes, 10%.
they have
fixed.
levied at 10%.
Yes.
So what is wrong in this?
Your Lordship, they cannot make a cess in this regard because the land acquisition is made in accordance with the 2013 Central Act. So likewise, in this Honorable Court,
No, there was a bar in that, in respect of the Mizoram Land Revenue Settlement Act.
yes.
But is there a similar bar in this?
Yeah, here they have slightest, in that case, they have says 10% with regard to land acquisition. Every land acquisition, they have deducted.
See, under the Mizoram Land Revenue Act, it says that cess can be collected. But later on, there was an amendment which says that cess can be collected provided it is assessment, what do you call, the acquisition is done as per the
Yes, yes.
state law.
Yes, yes,
But when the acquisition is done as per the Highways Act or as per the 2013 Act,
yes.
cess cannot be deducted.
Cess cannot be deducted.
So that is why this court has also held
Yes,
that
yes.
you cannot deduct cess refund.
Yes,
Now, in respect of MADC,
yes.
is there any such kind of clause which says that cess will be given, cess can be imposed if it is, acquisition is done as per the,
Nothing is there. Only that they said that every
So-
measurement or any other administrative works,
so how do you apply the principle here?
it cannot be applicable in the case. That's why we have come to this court.
Now, how do you say it's not applicable?
Because, Your Lordship, as you know, in this case, the acquisition is in accordance with Central Act, and this is a Revenue Act of the MADC. And even if they have not mentioned that they will be deducted from the land acquisition compensation, nothing like that is there. And even though, Your Lordship, kindly see the award, they have already deducted administrative costs, 19 lakhs. So they have mentioned that for measurement and administration costs.
No, that's a different head.
Yes.
Administrative head or whatever, administrative cost or whatever. But this is regarding cess.
Yes.
So these two will be distinct heads, I think. Now, in respect of Mizoram Land Revenue Act, like I said, because of that amendment, there's a bar.
Yes.
But in respect of MADC, there is no such kind of specific bar. There's no amendment as such.
But in the ratio, Your Lordship, because the acquisition is made in accordance with the Central Act.
Maybe.
So, yeah, they have no Land Acquisition Act which was made by the MADC. So in this case, same ratio can be applied since the acquisition is made in accordance with Central Act. This MSDC Act is not applicable to my case to take cess from compensation because if you read out this, for the conduct of spot verification, survey, measurement, or any other administrative work. So it's not mentioned that it's for the compensation.
Do you have the MADC Act?
Yes.
Where act?
I have enclosed, Your Lordship.
No, I want the book. Not just the abstract. 2018 MATC Act. Just look for it. Ask the librarian.
So far as my knowledge, Your Lordship, this act is made in accordance with the Mizoram State of Mizoram, that the one they have deducted 10 cess, 10% cess.
I know.
So in accordance
maybe,
with
maybe.
that,
But
yeah,
the thing is that in the State of Mizoram Act, it's very specific.
yes, specific.
Very specific.
I know.
That
But
is
in
why-
this case, it's not applicable to the compensation. I feel that because the B is mentioned that for conduct of spot survey and measurement or any other administrative work. In the compensation, they have already deducted administration work for 19 lakhs, where again they have deducted 10% cess.
So that is regarding cess. We'll go to that aspect.
Yes,
Now the other aspect is section 80 interest.
yes,
If
We-
possession is taken,
Yes.
your payment of the compensation,
yes,
then interest has to be given
yes,
at the rate of 9%.
yes. If not paid within a year, again, it's
After 1 year, it's 15% again.
yes. That is, I have a judgment covered my case
What do they say?
yes.
Who has filed the counter affidavit?
in this case.
Yes.
MADC,
What do they say?
they
Whether
said,
you're entitled to the interest or not.
they said that they have not mentioned properly. Even the government of Mizoram said that if the court directs, will calculate the interest. They
Okay.
say.
What about the reference to the authority, section 52 and 64?
Yeah.
What
in
do they
this
say?
regard, they said that if this court, I'll
Directs.
come to that, directed, since the LA Act 2016 is pending before the division bench, that's why they cannot appoint the authority. This is their stand. I'll read out.
What is your reply?
I didn't make a reply because, Your Lordship, the law is very clear. Whether in 2016, 1894, 2013 LA Act, they have to constitute the appropriate authority, whatever LA case. Even in the 2016 Act, section 60, it's mentioned.
2018 Act,
16 Act,
16 Act,
yes, Mizoram State LA Act,
section 60.
60, it's mentioned. And even in the 1895 repeal, it's already repealed.
Give me section 60. Section 16, section 60. This is, okay. Section 60. So you're saying whether it be 1894, whether it be 2016 Act, whether it be 2013,
13, they have
there
to,
is no escape.
there is no escape. They have to
You have to
appoint.
have a reference authority.
Yes, you have to have.
Otherwise, whatever is awarded by the collector, you have to quietly accept it.
Yes, know where
That-
to.
that cannot be.
Yeah, yeah. So he already submitted before the collector, and the collector, CHDC, however, the collector has no referred the case to the authority.
Because there is no authority.
There is no authority.
Who will appoint the authority?
State government,
State government
yes,
under section 52.
52. 51 and 52. Yes.
This will be for a particular case or a permanent authority,
This, in according to
courtmaster.
law, it's a term for 3 years first.
Is it so? Where's
Yeah,
that?
term of office of presiding officer 54. And
3 years, or he attains the age of 65.
yes,
So if the office, presiding officer is appointed at a young age,
yes.
he will continue beyond 3 years also, till he is 65 years.
Or 3 years or until he attains the age of 65.
That's what I'm
years.
saying.
Yes,
Supposing he is only 50 years,
right,
then for 15 years he can be there as the authority.
right. It seems that
Okay. The appointment is done by the state government,
state government. Here they have mentioned here.
appropriate government.
Appropriate, yes. Even in the affidavit, Your Lordship, para 13, they have mentioned here. If the Honorable High Court desires to constitute the said authority, government of Mizoram is ready to constitute anytime, at any time. Their affidavit, para 13. 13. Respondent number 3 and 4.
3 and 4.
3 and 4.
Three and 4.
May I read, Your Lordship?
No, just a minute. Which paragraph?
Paragraph
Paragraph number
13.
Page number 7, Your Lordship.
Yes, read.
That with regard to the statements made in pair number 15 of the writ petition, I say that since the MLA Act 2016 is sub judice before the Division Bench, Guwahati High Court, the Government of Mizoram could not establish the Land Acquisition Rehabilitation and Resettlement Authority. If the Honorable High Court desires to constitute the said authority, the Government of Mizoram is ready to constitute at any time.
Okay.
And kindly see a lot of paragraph 11 regarding interest. They have admitted that here.
In pair number 11, page number 6, Your Lordship.
It is.
May I read, Your Lordship?
Yes.
That with regard to statements made in pair number 12 and 13 of the writ petition, I say that if the Honorable High Court finds it fit to make such calculations as per section 80 of the RFCTLA Act 2013, the same will be done promptly.
Fund will come from center. That's why.
That's right. And with regard to the section 80, Your Lordship, it's a covered case. I have enclosed the judgment of this Honorable Court, Your Lordship.
Section 80.
Oh, regarding section 80,
Interest.
interest. Annexure 8. Yeah.
No, the act itself provides for interest.
Right.
So
The judgment is,
we can't go beyond that.
yeah, from the position,
It is
yeah,
at the wisdom of the legislators that this act has been enacted. Section 80 has been provided to give the maximum benefit to the landowners. So it has to be complied with.
yes,
Now, the only question now is regarding that cess part, that
yes,
that we need to just look into that aspect, whether cess can be imposed upon by them or not. You are saying that similar principle which was done in the case of the state of Mizoram
Your Lordship, the
should be
judgment,
applied.
if you allow me to read the judgment of this Honorable Court,
Which judgment?
regarding that state of Mizoram Revenue Act that says they have taken 10%, where this,
Have
it's
you have annexed?
mentioned here.
You have annexed it?
Yes, I have annexed it.
Okay, before that, what about that appeal? What is the status of that appeal? Government?
2016?
Regarding the challenge made to the decision of the single bench regarding 2016 Act not being applicable. Still pending.
CAV. So far
CAV.
as our knowledge, it's already heard.
Dated?
Sometime in the month of September.
September.
Yes.
Okay, September this year. We are in October now.
Kindly see, Your Lordship, the judgment, Annexure 7,
Page?
page 69. And operative portion, Your Lordship, it's paragraph 14, that is in page 76. You got it, Your Lordship? May I
yes.
read?
Yes.
In the present case, the petition lands have been acquired under Railway Act 1989, which has been enacted by the Parliament. Also, the government of Mizoram Land Revenue Settlement Department issued a notification such and such, which provides that during the period, the Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016 is subsidized. Lands for the national highway projects and railway projects in Mizoram shall be acquired under the relevant provision of the National Highway Act 1956. Here, the Railway Act 1989 respectively. In view of the above, Your Lordship, here kindly note that in view of the above, it is clear that as acquisition of the petitioner's lands have been made under a central act. Rule 47(4) of the 2013 rules and amendment rules would not be applicable to the case in hand. Accordingly, the respondent number such and such could not have invoked the provision of such and such, deducting 15% cess from the compensation amount awarded to the petitioner in terms of award number 3 of 2019. And so far as my understanding, Your Lordship, since the acquisition process is in accordance with the Central Act, not Mizoram Act, or not Autonomous Act, so it cannot be applicable.
Please come to page 75,
75.
paragraph 12.
Yes,
Now, here is one abstract of Rule 47(4)
right,
of 2013 rules.
right.
Now, this Rule 47(4) provides that acquisition under the LA Act of 1894 and deduction of 15% land value towards cess.
Right.
Now, this 47(4) has been amended
Yes.
in the, which has been highlighted here in paragraph 13, abstracted.
Yes.
Amendment of Rule 47.
Yes.
Now, at page 76, on the top of the page, you'll see any land acquisition law or policy of the government of Mizoram.
Yes. Policy.
So, that Land Acquisition Act of 1894 has been replaced.
Yes.
Now, it is any land acquisition law or policy of the government of Mizoram.
Yes.
So, admittedly, under the Railways Act or the Forest Act or 2013 Act, this is not the policy of the government of Mizoram.
Yes.
So, you cannot deduct cess.
Yeah. Right.
So, it is clear
Clear.
in respect of the what act we call this? Yes, Mizoram Land and Revenue Act rules.
Yeah. 2000. Yes.
Now, coming to the MADC law,
Yes.
MADC Act or rules, what does it say?
It's not saying the land acquisition at all.
So that
It's
is
only simply saying that the conduct of spot survey and measurement of any other administrative
we are
work.
concerned with which rule?
B, 22 2B, page 20,
Section, I think. Is it section, isn't it?
section
This is an act.
23, 2,
Section
23 2B.
23. 23 2B.
Here it's not mentioned land acquisition at all. Nothing is mentioned. To collect and levy cess to the extent of 15% or cost or charge, which may be increased or decreased and fixed by the executive committee from time to time by official order or notification from any landholder from the value of the land and on any other ground and in the manner as may be prescribed from time to time for the conduct of spot verification, survey and measurement or any other administrative work. So this administrative work, with this regard, Your Lordship, it's already deducted 19 lakhs.
Where is that administrative work?
Here it's mentioned here, otherwise as here, or any other administrative work. So far as my understanding, so this administrative works, any land acquisition for measurement and all these things.
Just a minute, Ms. Dinari, let me read.
So this law cannot be made applicable to the case of the compensation at all.
Discretion is given to the executive committee to levy cess, collect or fix control revenue cess, cost, charges payable, land and so. On the ground, the manner, on any other ground and the manner as may be prescribed from time to time for conduct of spot verification, survey, measurement or any other administrative work or otherwise. Now, where is that notification?
Even in the notification, Annexure 6, there is no mention of the land acquisition at all. Page 68,
68.
yes.
This is the same thing which has
Same
been.
thing. So they cannot levy cess on the compensation at all. Here the court,
Question is there being any levy of cess for any landowners on land and for any land documents?
yeah, it is there in the separate. For that only they made, I feel that.
No, no.
If,
See, the rules or the act says that the executive committee can levy cess or this kind of, like any amount for verification, survey, measurement, administrative work, leaving aside the compensation part.
yes.
Ordinarily, for any landowners,
Ordinarily, yes.
any landowners,
Generally, any
for any
landowner.
landowners, are they imposing any cess?
For that, they have this, they have made this section, I feel that. So far as my understanding, because it's not mentioned at all land acquisition or compensation at here. If
No.
I approach the this revenue authority to conduct my to measure my land, so they can cess. It seems,
They can take cess.
yeah, they can take cess according to this.
Are they taking cess?
I don't know.
You leave aside compensation part.
Yes,
Compensation comes in bulk.
yes,
If anybody who has got land
I know.
under MADC,
yes.
he wants to demarcate
Right.
or he wants to ask for demarcation or verification or survey, does the MADC levy cess for that? Are they required to pay?
I don't know. Beside this section, they have another. I don't think they'll have. So far as my knowledge.
To collect and levy cess to the extent of 15%.
Yeah.
15% of what?
Yes. For what? That's
15% of what?
Yes.
And 10% of what?
Yes. Nothing is mentioned. So
15% of the value of the land or 15% of the expenditure or something like that.
it's not mentioned there.
Merely saying 10% or 15%, what
Yeah.
does it mean?
Yes.
Now, coming back to the Mizoram Act,
Mizoram Act. Yes.
what did it say? No, not this one. Okay, this is not this one. It says 15% of the land value.
Yes. Land value. It's correct here.
15% of the land value. Now, MADC Act does not say 15% of what?
Just saying 15% or cost or charge, which may be increased or decreased by the executive committee. From where they'll take, it's not mentioned. It's not written.
I apologize to interrupt, Your Lordship, but just for the sake of clarity, if Your Lordship can kindly turn to page 68, that notification. It says 10% from the land, from any landholder from the value of the land. 10% from any landholder from the value of the land. So 10% is on the value of the land.
This is in conformity of section 23, subsection 2.
Yes.
Yes.
Where does it say in section 23, subsection 2?
It's not saying.
In exercise of the power conferred by section 23, subsection 2 of the Mara Autonomous District Council Land and Revenue Act 2018, in the first line itself.
No. Where's the source?
Source would be 23.2.
23.2 does not say anything about the value of the land. It just says 15%. Good thing that you pointed out in notification.
It does, Your Lordship. I'll read
Where?
section 23, subsection 2b. To collect and levy cess to the extent of 15% or cost or charge which may be increased or decreased and fixed by the executive committee from time to time by official order or notification from any landholder from the value of the land. That would be the source in my humble opinion.
From the value of the land. From the value of the land.
Similar to the Mizoram rules.
So next question is, do you collect cess from others also? Those who are not receiving compensation also?
That information, I don't have it ready with me, but I can find out. But
Just
in
find
my-
out. Just
Yes.
find out. Since we are out of time today, we'll not just stop thing. We'll not just take a call at this stage.
Yes.
Compensation component comes in a bulk. Okay, 15%, 10% cut. Easy. But when it comes to individual, he says that, please verify my land. Then will you tax him? Say that we'll take 15% of the value of your land as the charge. Do you do that, or it's only for compensation? Because the notification does not talk about compensation.
Yes, I agree, Your Lordship. I can verify.
We might be slightly short of time on tomorrow. We'll
Yes.
have it perhaps some other day, not tomorrow.
Wednesday?
Wednesday, perhaps we'll have a DB.
Okay. Thursday, Your Lordship, I have personal
Thursday you have
difficulty.
problem. Friday there's
Friday
also slight
again,
problem
yes.
from my side also.
Let's see on Wednesday if time permit.
But it's a DB day, Ms. Dinari. There's some hearing matter fixed on Wednesday, if I'm not mistaken. It's a state appeal, in fact, some state appeal. How many matters are there for Wednesday, DB? Any?
Yes.
I'm saying this
Yes.
keeping in mind the kind of engagement we are having
Fine, fine.
this week and on Monday also.
What about Your Lordship, Monday, 28?
Monday might be difficult again.
Oh.
Yes,
it's
because
okay.
we are having that writ appeal that was set by the Supreme Court.
Huh.
We're going to have that hearing on Friday. It might carry on to the week after. I don't know.
Yes,
So that's why
29
I
will
think
do.
29 would be
29
safer.
will be convenient.
Yes.
Actually, more or less, things are clear. We need some clarification, especially on this point. On the other points, I don't know, Miss Zarem Sangpu, you might want to say something
In
regarding
their affidavit, nothing. They have
Miss Lalnun Louis' affidavit supports your case. They are ready to do the measurement or the calculation as and when directed.
and even CGC also, they have no dispute regarding,
There's no appeal as such, isn't it?
no appeal.
In respect of this WPC 160 of 2016,
No,
224 of 2016, or 53 of 2017?
No.
No appeal.
no appeal.
Basically, Your Lordship, the reply would be that I will be on cess. Ms. Zarem Sangpu will be on the interest. My learned
State
friend
is
will be on the
already
authority.
paid, Your Lordship.
I mean,
they have,
the argument.
they have already paid, but they have, it's lying before the collector. They have, in their affidavit, they have said that, says, 10% says.
It hasn't been released to the council.
Yeah, MADC. It's with the collector.
It's with the collector.
Yes.
Okay.
In their affidavit, they have mentioned.
How many other cases are coming up on similar subject?
Only two. These
Only
two
these
cases.
two as
These are
far
the two.
as I'm aware of.
Yeah.
So it's in a way it's quite crucial also,
Right.
because I think there are so many other cases that road construction.
So
Sophie,
far as
Lucky,
my
whatnot.
knowledge, Your Lordship, other compensation is National Highway. This is BRTF Pro. So National Highway, there's some says it will come up.
National Highway will be under the constructed by whom? NHRDC?
NHRDC.
Yes, yes.
Okay.
This is BRTF.
2006, isn't it? Construction.
7.
7.
Yes.
And what about that amount which you had received? It's damages.
Fruits and
Damages
tree-
to crops
crops,
and plants.
yeah,
okay.
yeah.
Crops and fruit bearing trees and all that.
And some shifting also they've given.
Shifting.
Yes. This is for land acquisition only.
But those are components which is in addition to the compensation for
Right,
the
right.
land, isn't it?
Before, they have given that crops and they denied to give land. So they have approached this honorable court.
What did I say? I did not say anything. Okay. List this matter again on 29th of October 2024 for further hearing. Stop. Mr. Lal Fakoma, learned counsel appearing for the MADC, shall obtain instructions as to whether cess is being levied or deducted from other land owners who are otherwise not receiving land compensation. For demarcation, verification, and what else?
Survey.
Measurement,
Measurement,
Survey.
and what else?
survey.
Survey, etc. By the next court date.